Good morning, everybody. Today's meeting of the Maryland Public Service Commission is now in order. Today we're going to be discussing rulemaking number 65, revisions to COMAR Title 20, Subtitle 31, Chapter 1, Regulation 2, and Title 20, Subchapter 31, Chapter 3, Subchapter Regulation 6. The purpose today is to discuss proper notice given to occupants of master metered buildings. We have a petition from the moving parties today, that is PEPCO, Delmarva, and the Office of the People's Counsel. We'll hear comments from interested parties, although we've read the filings that you've made, and we have those petitions before us. Before we get started today, are there any procedural items to bring to the Commission's attention? Seeing none, I would ask that the moving parties please approach the table. Good morning. If you could please make an appearance.
Yes, good morning, Mr. Chairman, Commissioners. Mikhail Raker on behalf of the Maryland Office of People's Counsel.
Good morning, Mr. Chairman, Commissioners. Donald Hayes appearing here this morning on behalf of Washington Gaslight Company.
Good morning, Mr. Chairman and Commissioners. Matthew Seegers appearing for PEPCO and Delmarva Power.
Thank you. Who would like to give the opening statement on behalf of the panel?
I'm happy to do so, Mr. Chairman. So first, we'd like to thank the Commission for accepting our petition for rulemaking and scheduling this rulemaking session. As noted in the petition and in staff's comments, the proposed regulations stem from the termination of service to Lynn Hill Condominium Development, Inc., master meter building in Prince George's County, Maryland, by PEPCO and WGL. The Lynn Hill matter was docketed as case number 9430, and in their review of the Lynn Hill matter, the parties further discovered that additional issues related to incomplete customer notices, including the content of service termination notices used by PEPCO and WGL, were included. These additional investigations into PEPCO's notices to customers and WGL's notices to customers were docketed as case numbers 9444 and 9445, respectively. A main point of disagreement between the parties in all these cases, 9430, 9444, and 9445, was whether COMAR 2031-0306, titled Tenants in a Master Metered Building, requires a utility to provide individual termination notices to master metered condominium residents and occupants with the contents set forth in COMAR 2031-0206, the required content of a notice of termination, exclusive of the customer's specific information, such as the customer's account number and the total amount due. In a good faith effort to resolve this matter, the parties reached settlements in case numbers 9430, 9444, and 9445. As part of the settlement provisions in 9444 and 9445, the settling parties agreed to file a petition for rulemaking to clarify the minimum content of service termination notices to individuals who have a legal right to reside in master meter buildings, such as whether such persons are owners, renters, or occupants, including the non-customer specific content set forth in 2031-0206. So just a little bit of background.
Thank you, Mr. Ricker.
So OPC supports the requested revisions to COMAR attached to the petition for rulemaking filed in this matter, as this is a consensus-driven proposal to clarify and bolster the Commission's regulations to ensure that residents and occupants of master meter buildings are provided essential information about their health and safety benefits and consumer protections. And as noted in its comments, we recommend that the Commission adopt the proposed regulations. In response to the Commission's notice in this matter, staff and Baltimore Gas and Electric Company filed comments recommending some modification to the proposed regulations, and Potomac Edison filed comments expressing some concerns about the process in this matter and noting some questions about the proposed regulations. So at this point, I'm happy to walk through each of the proposed regulations, or alternatively, I can address the comments filed by the other parties.
I don't see a need to go through the proposals. We have them before us, and it might be a better use of time if you'd like to respond directly to BG&E staff and Potomac Edison's.
Okay, thank you, Mr. Chairman. So, in going through them systematically, staff proposes two modifications to the proposed regulations. First, staff suggests that the utilities be required to maintain a list of residential addresses associated with the master metered accounts in the master metered building, and I think my colleagues will briefly address that particular proposed modification. And also, staff has proposed to modify proposed 2031-0306H to require that a utility also provide a description and documentation of how notice was provided or is being provided to the building occupants when the utility notifies OPC and OER. The petitioners have no objection to this proposed modification and look forward to reviewing any specific language proposals that staff may have. In regards to BGE proposes three, basically, modifications to the proposed regulations. First, BGE proposes to modify proposed 2031-0306C, the process by which a utility can request a waiver of the occupant notification requirements set forth in proposed 2031-0306B. And specifically, BG proposes to remove safely from that first line of the proposed regulation.
Right, how do you feel about that?
So we understand the concerns that BGE notes, but in our view, removing that word would basically expand the waiver allowance that's currently in place.
But what about BG&E's argument that they say if there's a landlord or property owner that won't provide them with access? We're not talking about pit bulls.
Sure. So if the company can't access the property, then certainly they can't safely post the notices, would be our initial response. The company can request or ask a sheriff to accompany them or other law enforcement officer if really necessary, and if still they can't access the premises that may very well fall under the required regulations.
So you read safely to be very, very broad.
We would read it certainly broadly. If an alternative could be to keep the initial subpart C as is and add an additional subpart that says, so we would be saying if they can't enter safely, or if the utility has used all reasonable means at its disposal and cannot enter the premises, they can request a waiver. But as provided, we would oppose the modification because it would unnecessarily open that waiver requirement. BG also proposes to change the proposed period for commission action from 60 days to 30 days. We don't oppose this proposal and leave it at the Commission's discretion. Second, BGE proposes to modify proposed 2031-0306E9, and specifically they note either deleting or modifying this provision to avoid customer confusion. In drafting this part of the proposed regulation, we were in touch with the Office of Home Energy Programs, and when we shared BGE's recent comments with the Office of Home Energy Programs, they were in agreement that there might be some confusion, and so the parties would not oppose language to clarify that particular subpart, including that assistance would be available for relocation. So not deleting, but just clarifying. And lastly, BG proposes to modify 2031-0306J, the requirement that each utility identify and maintain on its records those accounts where service is provided to residential master metered buildings to ensure that service is not terminated prior to complete compliance with all proposed requirements in COMAR. And specifically, they, in essence, propose to shift the responsibility to the customer of informing the utility that service is being provided to a master metered building. And we cannot support this proposal, as basically, as stated, we see it as, or at least OPC sees it as undermining the intent of the proposed regulations.
How is BG&E supposed to know whether or not a property, a customer has a master meter? As of now, BG&E relies on the customer to tell them, and when the customer does so, BG&E has a system in its computers that allows them to make that notation. How do you solve that situation?
So again, we are understanding of BG's concern, but we've also seen the situation as occurred with Lynn Hill, where notice was not provided to the residents of that particular building.
We know that well. What's your solution here?
So certainly, at least BGE can proactively engage its customers in an attempt to understand which customer is a master metered residential customer. Our understanding is that WGL maintains a record of its residential master metered customers. So certainly other utilities can follow suit. The end goal is to ensure that the difficult circumstances that occurred in the Lynn Hill matter don't happen again. And so if you're dealing with a condominium association that's non-responsive and is not making payments and it's subject to termination, you have two questions. One, does the association know that it is their responsibility to notify the utility, which would then provide added benefits to the occupants of the premises, and will they actively notify the utility? And if they don't, then you can have a situation like occurred in Lynn Hill, where the occupants were not notified of all of their rights.
I still don't hear a proposal. What would you suggest that BG&E do?
Well, we would rely on their expertise in their customer communications and actively reaching out to their customers in an attempt to understand which of their customers are master metered residential accounts, or which of their commercial customers, I suppose, are master metered and have residents and occupants living in those premises.
Just on that, would it, as far as trying to help the utility determine how the buildings are set up, would it be harmful to the process if they at least be required to ask, to inquire of a new customer what their intention is going to be? I mean, is there harm in accepting BG's recommendation? So
I thank you for that question, and we do want to make a distinction. We support asking new customers if they're a master metered customer, but we don't think that should alleviate the utility's responsibility to comply with the COMAR requirements for all of their current customers. So in essence, we want to again avoid a situation where if a customer doesn't proactively, meaning a current customer doesn't proactively approach the utility and say, I'm a master metered customer, what we can see happening is later, when a utility terminates service to that customer and doesn't comply with the regulations, the utility can hold its hands up and say, well, the customer never told me that it was a master metered customer. And then the whole effort of putting these regulations in place would have been for nothing.
So you would ask every new customer, let's say BG&E or Pepco, whether you're a master metered?
We would support that.
I don't think a lot of people would know if I move into a new home and now Pepco's asking me, are you master metered, and I'm in a single family home. What does that mean?
Well, so as I understand it, master meter would be for larger complexes, and it would be the association or the building management that would in essence be working with the utility to set up that account.
So the utility will not be asking all new customers?
Well, so the customer is is the association or the management company, and those that live in the building would be the occupants
So,
of the
so you're
building.
saying that the utility should only ask commercial new customers, not residential?
So I'm not 100% clear if there are residential master metered accounts, meaning if that's a designation. That would be for my colleagues here. Or
I don't think that
utilities.
that is.
I'm not 100% sure.
I'm just trying to understand if you would ask all new customers, regardless of rate class, whether or not they are master metered.
I understand your question, sir. I think it would probably be limited to those customers that can be master metered, meaning the commercial customers, because a residential customer simply would not fall into that class, would be my understanding, but I'm happy if my colleagues...
Well,
have
why don't we move on to
information.
the Potomac Edison? I think we're done with BGE, is that right?
That is, yes.
Commissioner Herman, sorry.
Right, that's okay. Before we move on to that, with respect to the waiver, isn't it, you argue that the waiver just safely shouldn't come out, but couldn't you argue that the waiver is inappropriate when they make it? When they come here before the commission, you're going to have an admin. Can't you just argue that it's inappropriate, the waiver, at that time?
Potentially. In the way that the regulations are worded, it's unclear if it would end up in an admin or if it would just be a commission action.
Are you aware of the commission ever waiving a regulation without having it before an administrative meeting or some sort of a review or hearing of that?
I'm not, so I stand corrected then, Commissioner. It would be an admin matter. And so, just so I understand your question, the hypothetical would be the utility asking for this waiver.
Right, and if OPC
providing-
thought it wasn't appropriate because they hadn't done enough, they hadn't described it in their letter that they had done enough to be able to qualify for the waiver, they hadn't made enough of an effort before asking for the waiver, couldn't you argue then that they wouldn't be entitled to the waiver?
We certainly can. I think that might be a possible way to clarify that or reach a consensus on that matter.
Yeah, because it seems to me that, if OPC is uncomfortable with the waiver because the utility hypothetically didn't do enough in OPC's view, then OPC could make that argument when we review for a waiver, because we don't waive regulations lightly. So we could, in fact, review it at that time, I would think, right?
I think that could be a potential way to resolve that matter, yes.
Okay. Thank you.
Thank you.
Let me probe a little bit on that word safely. Safely really is describing the manner in which notice is given, not the purpose of the requested waiver. Is that right? It's not a request necessarily, although the safety in a pit bull situation could be the reason, but it's really describing how the notice is posted safely. Is that your understanding of that word? It's not really saying you only request a waiver for safety reasons because of safety reasons, but it's describing the manner in which the posters of the notification perform that function. Is that right?
Well, that would be accurate. So just to explain that further, the idea would be exactly in terms of safety for the individual attempting to post those notices.
So when BG&E argues that there could be reasons beyond safety, that's true. That would be the matter before us when the waiver is requested. But it's not the sole purpose of requesting a waiver is not limited to safety, but by including that word safely.
So the
I'm helping you out, Mr. Rick. So
I understand, Commissioner. I would agree with that then.
okay, very good. Thank you.
Mr. Hayes.
Yes. Thank you, Mr. Chairman. I'm Donald Hayes, appearing on behalf of Washington Gas. Washington Gas supports the proposed modifications to COMAR. Came out of a settlement with OPC as a result of case number 9445. There was lots of discussion as to what changes could be suggested to COMAR to sort of resolve the problem that we had in that case, and that was what type of notice is required in the case of a termination of service to a master meter department. And that was an issue that Washington Gas was concerned about, whether under COMAR we had to include certain information in that notice that was posted on the doors or not. As a result of lengthy discussions with OPC and Pepco Delmarva, we've come to resolve the those concerns, and it's reflected in what we have proposed to the Commissioner, what OPC filed it. So we support the changes to COMAR. In terms of the changes proposed by staff, we would disagree with staff's first recommendation that we have to maintain a list of residential addresses associated with master metered accounts. Essentially, there's no way that we would have access to that, a mailing list of customers behind the master metered account. It's possible, but unless the management provided that to us, there's no way that the utility would have access to that information. And that's why in the notice provision in 20.31.03.06B1 that we would individually notify occupants by first-class mail if the postal address is readily available to the utility, or alternatively by flyers or door stuffers if that is not available. And so, to adopt staff's recommendation would essentially eliminate that option that was proposed in COMAR there. I think it's unworkable, and it would also raise all concerns back if you were to move forward with the termination, and that was the rule, that you had to have a list of the names and addresses of occupants behind the meter. Undoubtedly, there would be disputes about someone's name was wrong, someone was omitted. It would just create complexity and liability in the situation where we're trying to avoid it earnestly by posting notice the best we can. If we had the mailing address, I'm sure we would mail it to the belt suspenders approach. We're going to do everything that we can to provide notice, but we shouldn't be required to maintain a mailing list. That information is not available to us. Presumably the management would have that, but management can change in these buildings. We just don't think that that's a practical requirement, and it would muddy the waters. What we've proposed is a clear and definite way to provide the notice, and that is, if you don't have mailing list, we post it and provide all of this information. We think that's a clear, workable way to resolve this. As far as staff's second recommendation,
Can I just ask a question on that?
Yes.
So what sources would the utility deem as, I guess, useful in this case? I mean, for instance, ESTAT. I mean, if we just look at the Lynn Hill case,
Yes.
you could get all the information through ESTAT, public available files. If that type of data is available, then should we expect the utility to maintain those lists?
well, I'm not sure that would be an accurate list. It's not something that we do now, and I'm not sure that it's necessarily up to date. Maybe that the management doesn't even know who is in the buildings. We thought that by posting, putting this notice on every door, plus posting it in prominent places in public spots in the building, on the elevator entrances, the front, any entranceway to the building, in the mail room, in the laundry room, everyone should have notice of what is happening. Plus, they'd have a notice taped onto their own front door. I think it would be, an absolute certain way to provide notice to everyone that is there, whether their name is on a list, mailing list somewhere or not.
Okay, so you're requesting that the mailing requirement be eliminated then?
Or not be added, yes.
Or not be
Yes.
added, okay. Thank you.
As far as staff's second recommendation, we don't oppose that. If we would like to see what the final language is, but it's in effect, we would document how notice was provided, and we think that just creates additional clarity, and we lay out that information in filings to the commission, and this is how notice was provided. Notice was posted, on every door. It was posted at various common areas in the building, so that there's no question about how notice was provided.
Thank you, Mr. Hayes.
Mr. Hayes,
Yes.
I wanted to ask you a question. I think I heard you say it, and I think I understand it, but I want to clarify for the record. So on page 6 of the petition, there's a paragraph D11, disagreement about notice to occupants of master metered buildings, and it describes a disagreement between OPC and the companies. Okay. I believe that the red line of the regs that you have before us in section 06 resolves that or reconciles that difference. And I think I heard you say that, but the comments of the parties don't seem to directly address it, or at least it wasn't clear to me that they addressed it. So could you clarify that for this commissioner?
I'm not sure, Commissioner O'Donnell, that I understand your question. I'm looking at which specific section in COMAR are you referring to? You
I'm
mentioned the red
talking
line.
about your petition, the joint petition.
Well, the primary dispute between Washington Gas and OPC was what type of information is required in a notice that is posted. Specifically, there was, in notice of termination to a residential customer, for example, you have to provide information about if you are elderly, if you're...
Mr. Hayes, I'm asking you if that disagreement is resolved.
Oh, I'm sorry. Yes, yes.
That disagreement described on page 6 of the application is resolved in the red lines filed for the regs.
That is correct.
Okay. That's all I'm clarifying.
Okay.
I think I heard you say that.
Yes.
I think I understand that, but I wanted to clarify that for the record very
Yes.
simply.
Yes.
Okay. Thank you, sir.
Yeah.
Appreciate it.
Mr. Hayes, did you want to speak as to BG&E's edits, or do you agree with Mr. Raker?
We concur with what Mr. Riker stated.
Mr. Seegers, do you have independent thoughts, or do you concur with the positions of those to your left?
We concur with both Mr. Raker and Mr. Hayes. And I would note that these regulations came out of a similar situation for Pepco. In our case, it was case number 9444. And to answer your question specifically, Mr. O'Donnell, we believe that these regulations do resolve the disagreement concerning whether or not the occupants of a master meter building need to be required certain parts of the notice. And that is about it, really.
Mr. Hayes, Mr. Raker suggested that Washington Gas maintains a record of accounts for service to master meter buildings. Is that correct? I'm talking about
yeah.
J in 06. J, I guess.
Yes, we provided a response to a data request where we indicated the number of master metered accounts that we have in Maryland, and we had specific numbers, and there are lots of such accounts in Maryland. So yes, we track it in our system.
Okay. And Mr. Seegers, does Pepco track master metered accounts?
As we learn of them, yes, we do, Commissioner.
And as you learn of them, so is it possible that there are some that are not, that you're not aware of?
It is possible, Commissioner. A lot of times we don't know if a property is master metered unless, first of all, if the customer informs us, or if a field technician goes out and makes a site visit, or if they go out to terminate service and they see that there's a large building with only 1 meter, then we will note the account and then go through these procedures.
Okay. So do we have any issue with proposed J because it's an affirmative shall identify and maintain those accounts for service and master metered buildings. I mean, do you have any concern similar to what BGE expressed that you may not know about them all?
We do not have a concern at this time. I can certainly see the perspective of BGE, and but it's not a concern that we share, just because of the fact that we are confident that once that if we are going to go out and terminate service, we will be able to identify if a property is master metered, and then we will go through the new procedures.
Okay, so that you're saying that since this is related to a disconnection, that you could say that even if you didn't know, that you wouldn't disconnect prior to compliance. If you went out there and it looked like a master meter, then you wouldn't disconnect.
Of course, yes.
Okay, so I guess we can ask BGE if that solves their problem, because then they would be able to tell when they went out there that it was master metered, and then be able to comply with go back and say, oh, we didn't disconnect it, we have to comply with all these regs. Okay, thank you.
Can I just ask, with respect to Jay, if we were to provide this as a going forward requirement for all new customers, and that there be a best efforts made by utilities to gather that information, would that type of stipulation be acceptable to utilities?
Do you want to go first, or do you?
We are fine with the language as proposed. It was part of the settlement agreement.
Oh.
But we would not,
I guess I'm referring more to the staff recommendation. So BGE's recommendation. I think it's BGE's recommendation. Oh, okay.
the first staff recommendation?
Yeah, I think I'm getting my recommendations mixed up. So, okay. But if we were to provide going forward and best efforts, is that acceptable language as well? If that, again, enables us to maintain the best possible list we can at this point in time?
I think that would create enormous record keeping and complexities if we were to try to maintain a current mailing list of...
Oh, I'm sorry. Okay. About just the master metered buildings.
We know our master meter
Okay,
buildings.
you do, and
now,
BGE and PEPCO, is that?
We do maintain a list of the accounts that have been identified as master metered.
Okay,
Yes,
so
we
this
do.
is more just, I guess I'm speaking to party's not at the table. Okay, great, thank you.
Okay.
How do you want to go about this? Do you want to respond to Potomac Edison's 10 points that they made at this point?
So we can respond to any of those points which the commission has specific question on or about.
Do the settling parties have consensus with regard to these 10 points set forth by Potomac Edison? They're all listed on page 3 of the Potomac Edison
Well,
pleading.
I think they're more in terms of questions or concerns rather than sort of proposed modifications. So I'm not sure that we would have necessarily a consensus response to each one, but I'd be happy to go through each one.
In that case, why don't we have Potomac Edison explain any of their concerns from the table? At this point, does the panel have anything further to add to its opening statement?
Mr. Chairman, I have some, what I'll call technical questions. Would you like me to approach those now, or would you like to hold off on that?
If these three gentlemen could answer those questions now, why don't we get them out of the way?
Okay.
And then we'll have the other parties make their opening statements.
Okay.
I have some as well.
All right. So I'll address this to whomever wants to answer it. With respect to B1, attachment B1 to the OPC request. There on 13, the definition of master metered building. So, you were there? Okay.
Yes.
So this other charge under the authority of PUA 7303, is that meant to apply only to the other charge, or to also rent, condominium fee, or other. So you see my problems. There's a charge, we have a charge under the authority of 7303. Is that meant to modify rent, condominium fee, and other, or just the other?
I would read it as modifying just the other,
Just the other.
Commissioner.
Okay, so if we needed to address that, that would be like a technical change. We're not changing the meaning.
Yes, Commissioner.
Okay. All right. Let's move on to attachment B2. And you've changed the A, termination of service in a master metered building. You've changed it to building. But then elsewhere in the same regulation, you use the word premises. So I'm kind of confused. Are we supposed to be using building? Does premise have a different meaning than building? If you look at E1, E3, E6, all of those use the word premises. So I just want to make sure we're being accurate when we're using the appropriate words.
Yes, I appreciate that. The reason I believe we changed master metered premises to master metered building was to align it with the definition of master metered building.
Right.
And so when we talk about premises, we could, I suppose, change all premises to master metered
The master metered building. That's the intent
Yes,
when you
the
use the word premise?
premises was synonymous with master metered building.
Okay.
I think in the way that it was drafted here, but certainly for clarification purposes, we can.
Okay, so that could be another potential technical change that if we, wanted to avoid confusion, we could go with master meter building everywhere it says
could,
premises in 0306.
Yes, I'd have to take a look at all of those instances, but I believe that
believe
that
so.
would be
Okay.
a positive clarification.
And have you very carefully gone through and confirmed that where you mean customer, and where you mean occupant, you mean occupant? Because that's a very important clarification. I just want to, I'm not sure. Let me see if there was...
As an initial response, hopefully I'm not jumping the gun on this, but we did go through fairly carefully
Okay.
because with our partners, the utilities were certainly cautious in terms of who we address as occupant and who we address as customer.
So on E7, let's look at E7. The notices that are provided to the occupants include a statement of the customer's rights and remedies. So you intended that to be
The
occupants
customers.
versus customers. Just wanted
Yes.
to make sure.
Yes, and,
Okay.
and the rationale there is, again, just taking a step back, this would all potentially stem from a non-responsive or a not very active association or building management, which would be the customer, and so providing this information to the occupant may allow the occupant to raise concerns with that customer, then why aren't you taking advantage of these specific remedies, and can help facilitate that particular discussion.
Right. And when you say the customer's right of appeal with the commission, you mean the customer, not the occupant.
Yes.
Okay. Just wanted to be
Yes.
clear. Let me make sure I covered everything here. That's all.
Thank you,
Mr.
Commissioner.
Chairman.
Thank you, Commissioner Linton.
Thank you, Mr. Chairman. Good morning. I am directing your attention back to attachment B1. I'm also looking at section 13 again. Commissioner Herman picked up on a few of the concerns that I had, but I wanted to make sure that make sure I understand the proposal regarding the changing of the definition of master metered building. We had a mix of different fact patterns at the Lynn Hill complex. We had some condominiums that were condominium owner occupied, so the person actually purchased and owned the condominium, lived there. and you had other ones that were leased to a person that was not the owner. So in this definition, your intention is to try and cover both of them under the definition of occupant.
Yes, Commissioner. And so 13 would then, is it not?
Because one of them will pay rent to the condominium owner, and the other one will simply have a fee that they have to pay to the condominium association.
Right, and so 13 ties, well, so first 13 ties into 14, which is changing the definition of occupant slightly to say, meaning an individual who has a legal right to reside in the premises. And so that would be accurate, that particular distinction. The owner of the condominium unit would pay in their condo fees to the association versus the renter, which would presumably pay to the owner. At the end of the day, the termination occurs because the management company or the association doesn't pay whatever fees they're collecting to the utility. So it may be the fact that the owner doesn't pay those fees for some reason, the association doesn't pay those fees, but however the issue occurs, we still run into that issue that power is being terminated to a master metered building.
So
I hope that was responsive to your question.
no, I think we're getting there. I'm trying to make sure we cover what we're attempting to cover here, and we'll have to think a little more about how this plays out, because I understand what the catch-all in 14 is attempting to do, but as we know, legal rights change from day to day. So, a leasee today may not have the legal right to be there, but still be there. So, it's and the same thing could be true for a condominium owner. So, all right. Well, it's one to make sure that definition captures both of them, because they both have different legal authority. Assuming all legal positions are established and are correct and even accurate at the time. One is a leasee, one is an owner. So, and their responsibilities for payment are different. So, it may require a different, like two definitions in order to make sure you capture them both properly. But we can come back to that. We still have time there to figure that one out.
Yeah, so we can certainly come back, but in essence, their rights, as we outlined in terms of what rights they should be provided or what information they should be provided, may not change. But for clarity purposes, that may be worth delving a little bit further into.
So looking at the definition of occupant on the next page, number 14, did you take that from the Public Utilities article, or was that something that is that definition itself? And I'll just preface it by telling you the reason why I'm asking is that the Public Utilities article has a section that talks about occupants' rights in terms of complaints.
Mm-hmm.
And it's not with the Commission, it's with the Attorney General's office or with other consumer-based organizations that are county-based. So I'm wondering if we're following the same, if we're tracking what's in the statute currently, or are we creating something different?
I'm not 100% sure if it was if it was changed to align with that statute.
Okay.
I don't recall that particular point of distinction,
Okay.
but we can certainly review that.
All right.
I remember we were very cautious in changing 13 and 14 and made sure that they didn't impact any other particular definitions or requirements either here or elsewhere. But I don't recall that particular instance.
Okay. So along those same lines, do we know if the Consumer Protection Division of the Attorney General's office had a chance to, did they participate in any of your discussions?
They participated in the initial set of discussions,
Okay.
stemming from 9430. They were, I think, possibly involved in some discussions in 9444, 9445, but were not active participants and left shortly after those discussions may have started. I did forward them a copy of the commission's notice just a few days before comment was due, but I didn't get any particular response from them.
Okay. All right. In section B2, Commissioner Herman mentioned some of the concerns I had with section B1. I think there are ways to edit that a little bit so it makes clear that the utility should provide both of those notices and not necessarily have the option of one or the other, if the information is available. Just by changing a few words in there, we can get to that point. But I was also wanted to talk about section E, and I agree with Commissioner Herman throughout here that we need to make sure that this is a notice that's being sent in response to the directive under B1 and 2, which is going to the occupants. So there's a number of protections here that are, a number of statements here that are focused on the customer, and in particular on the customer's rights. And we want to make sure that the occupant is not, doesn't read this notice and think that those are rights that belong to the occupant, when in fact they're rights that belong to the customer.
And I think that's a very fair distinction because of those specific rights, a customer versus an occupant. And we do have some draft notices that were sent out in the Lynn Hill matter where I don't know if it was the exact provisions that we've noted here, but there was a distinction made in those notices between the rights of the association versus the rights of the occupant receiving that notice. And again, the rights do belong to the customer, but in our experience with Lynn Hill, where the association was not actively pursuing those rights, we thought it beneficial to include them here for the occupants to know what rights there may be that the association may not be pursuing on their behalf, and then either make sure that the association does so or seek alternative assistance with those rights. So it was done specifically and not with intent.
Well, the General Assembly recently changed some of the statutes to provide additional rights to occupants in these scenarios. So it would be worth referencing that as part of these notices, although I don't know that those rights would have necessarily been as useful in the Lynn Hill situation, but in other master meter situations they certainly could be. But in particular, I think it's worth taking a second look on sections 7, 8, and 9 to make sure that we're not conflating the two, so that occupants don't think that those are direct rights that they would have when they really are rights of the customers. So I have one other question or comment regarding section 10 in that same area, and then section H, which is a little further down the page. In my former life, this might be self-serving, but I'm wondering why the regulation proposes to notify the Commission's Office of External Relations regarding the potential termination of service to the customer when the occupant is receiving the notice and has the right to file a complaint with the Attorney General's office.
So the question is, why is OER specifically mentioned
Right.
here?
I guess to make it easier, would it also be appropriate to provide notice to the Attorney General's office, or to at least let them know that potentially a number of customers may be calling them to say, or excuse me, a number of occupants may be calling them to say that I have some concerns about what's happening at my address.
I think that might be a fair addition here. I think that issue was broached, but not included, so that might be a fair.
And I'm not trying to give more work to our colleagues on colleagues in state agency on the other side of the street.
But I think certainly the occupant can contact any of these agencies and probably receive useful information. Or at the very least, they would know with some of the other information that a customer has a right of filing a complaint and then can urge their customer to file a complaint with OER as well. But I think that's a very useful point in terms of including contact information for the Attorney General's office. We'll just have to make sure they're on board as well.
Yes, that
Well, I believe-
would not be up to me. But
Well, this provision, if I may interject here, paragraph H is a requirement on the utility to provide notice to these various parties that they're proceeding with termination. Isn't that right? You have to advise OER, OPC, and the Director of Social Services for the jurisdiction.
Mr. Hayes, are you suggesting that we shouldn't notify the Office of the Attorney General Consumer Protection Division?
No, the discussion sounded like it was, this is additional information to provide to the occupant.
I agree, but
This-
I
right.
think the point
This
of,
is-
maybe the point of the Commissioner is that we should equally notify, in addition to these parties listed, the Office of the Attorney General.
Yeah, and it's the utility providing the
Right.
notice directly to these
Right.
parties.
But they may get calls just like these other agencies may get, and therefore
Yes.
it would be appropriate
Yes.
to notify them as well.
Correct.
I think is the point that was just discussed.
And I guess maybe we're jumping the gun, but is that the comment for H as well as
yes,
E sub 10 and H as well?
right. That's the same comment. Yes.
Okay.
Thank you, Mr.
Thank you for those.
Mr.
Thank you,
Chairman,
Commissioner O'Donnell.
Thank you. Let me ask you about attachment B2E9. There's two parts to 9, and it says the statement that limited income occupants, a statement that limited income occupants may qualify for assistance, including for Part A, which is relocation assistance through Maryland 211, and Part B, utility assistance through our low-income programs in the state. BG&E makes the point that if they're not a customer, simply an occupant, they're not eligible for Part B assistance, and therefore you either need to take B out or you need to modify B to clarify that. If you've covered this, I apologize, but if you haven't, could you tell us your position on that suggestion?
And thank you, Commissioner, for that question. I briefly touched on it, but we would agree with clarifying B to add an additional couple of words or phrase that it would be for relocation and related to relocation.
Okay, so they wouldn't be eligible, just to clarify, they wouldn't be eligible for the assistance until they opened an account in their name, is your suggestion. Don't take B out, but modify it.
Our suggestion would be to modify B.
Modify
Yes,
it so that
Commissioner.
it's clear that they have to open their own account with the
Yes,
utility.
and
Okay.
again, in drafting this, we were in contact with OHEP, and we ran BG's clarification question through them as well, and they as well thought that it would be a useful clarification to keep it in terms of information purposes, but clarify subpart B.
Fair enough, thank you.
Do you have a proposal for us?
In terms of how to clarify it,
Yes.
um,
Would we start by deleting B as BG&E proposes, beginning with financial assistance?
I would. So I don't initially have a clarification at this table right now. I would again leave B, but clarify as worded. So I can certainly work up a clarification as the other parties are speaking and propose one.
Okay, very, very good. I just had one quick question. I know Commissioner Richard has a question as well. With regard to E6 here, a statement that the occupant should contact the customer of record to discuss any applicable rights. Why would you have the tenant contact the landlord to discuss their applicable rights, assuming the landlord is the one that is not paying the utility bills, as in the Lynn Hill situation? What business is it of the customer to be charged with the responsibility of telling its occupants what rights they do and do not have.
Well, so again, we were attempting to walk that fine line between the specific set of rights offered to the customer and the specific set of rights offered to the occupant, and certainly certain rights such as contesting the bill, reaching out to OER, and other things fall to the customer, and so in attempting to.
But the customer's not a social worker. What responsibility of theirs is it to inform their occupants of their applicable rights? If I'm the landlord and the customer comes, if I'm the landlord who is the customer and my tenant who is the occupant comes, I have no obligation to tell them all their rights and responsibilities, as in A, B, or C in this case.
So certainly those rights are with the customer and with the landlord. The only additional information this would provide is that the occupant can contact the customer and provide the specific rights that they can discuss. The customer, as we know, the purpose of this is the fact that the customer, meaning the association, the management company, whoever it is, may not be responsive and may not be reachable to discuss those rights. And so, therefore, we lay out some of those rights in the subsequent sections. And provide additional contact information for the occupant to reach out to other sources.
I don't see this realistic as currently drafted, putting the burden on the customer to serve as the caseworker for the occupant. Okay, thank you. Any further questions for the panel?
I guess I had, you asked basically, I was interested in how 6A, the section that the chairman was just discussing, would it work in fact. So if the occupant does need to have for purposes of illness or life support systems, needs to make that notification, they get the notice overall that in 14 days power is going to be terminated. What exactly happens at that point? Is it the direction that they're given that they're supposed to go to the customer, or I guess later on it says they can address the utility directly. Is that going to be clearly spelled out what the rights of the occupant is in this circumstance?
So the vision is certainly that they would be spelled out clearly, and again, some of the template termination notices we worked on in the Lynn Hill matter attempted to do so. Again, it was a negotiation, and there are certain rights that the utilities were adamant that belong to the customer specifically, certain rights that belong to the occupant, and so this was a way to attempt to negotiate that, provide the occupant with certain rights that they can contact the customer for, but other rights that they, as an occupant, per the COMAR provisions currently in place, can contact the utility about, meaning delaying this termination. And when they receive that initial termination notice, they will be provided with that information and can fill out a medical certification if necessary, or contact the utility and let them know that they are an eligible person and will be contacting the utility with their medical certification.
Okay, it would just be a concern that given that there's limited time, 14 days, and that the customer, the occupant, is clearly notified that if they have a life-threatening situation, if they're ill or life support systems, that they may need to address those issues directly to the utility to ensure that they go through the process, the form, in the time, in the limited time that they have. So I just noted that. And also in the discussion about the role of the Attorney General, when we're looking at the waiver provision for the utility, it's my understanding from the Public Utility Act in 7307.2 that it is an enforceable right that the utility may enter the common area of a condominium property at a reasonable time to post notice requirements of this section. So I understand that there'll be some discretion with the commission as to whether or not to grant the waiver, but should it be maybe spelled out that if they're not being permitted to enter the residence, then the customer is in violation of the law, and so therefore there may be an enforcement step that ought to take place before a waiver, the utility resorts to a waiver. Am I reading this correctly, and should that be maybe clarified a little bit?
So you are certainly reading that correctly. Additional clarification can be added. The idea is certainly that these all work together. So the Maryland statute does provide specific requirements and indeed allows possible enforcement of those. So in my prior comments at the beginning, I noted that a utility should take all reasonable steps, including possibly invoking a sheriff or other officer to come with them if they are not being allowed access. And so that was our initial concern with simply removing safely. It would possibly increase the scope of that waiver. Certainly the utility is, as noted here, would be required to document all of their efforts and then file those with the waiver requirements, and then it could be on staff, OPC, or any other party to contest that particular waiver. But the idea is that they would all be read together, and the utility would do its utmost and take any reasonable efforts necessary.
No, I appreciate that. I mean, obviously
that.
we have to read a lot into the process as we're looking at these lines in the regulation, but it seems that ensuring that before we jump to a waiver, the interest here is that we get notification to the occupants that the utilities do in fact, work with the Attorney General Office or law enforcement to ensure that the law is being enforced. If it's not, then we have a complete breakdown, I think, of
right, and that was our main motivation as well.
Yeah.
And so in crafting this, we certainly had a good faith debate between the settling parties about how best to craft this, and our end result was allowing a waiver in a narrow set of circumstances when maybe enforcement efforts or other particular actions didn't work.
Okay, great, thank you.
Thank you to the parties at the table. At this point, we will call up other intervening parties in this matter, although you should stick around for the remainder of the hearing in case we have additional questions. We'll have Baltimore Gas and Electric and Potomac Edison approach the table if they wish to make an opening statement.
Thank you.
Good morning, Mr. Chairman, members
morning.
of the Commission, Damon Krieger on behalf of Baltimore Gas and Electric Company. I'm also accompanied today with Patrick Dunn to my left, who's our Manager of Revenue Protection, and behind me, Mark Haynes, who is our Manager for Collections Activity.
Thank you, Mr. Krieger. We've already reviewed your filing on August the 15th. We've heard some of the proposals that you've made. Do you have anything in addition to add?
I would just say as a brief opening statement that I think as the Commission realizes, BG didn't participate in the underlying proceedings. We're not a party to the petition. We weren't part of the drafting discussions that took place too, and that resulted in the proposed regulations. And really to that end, I think Potomac Edison raises some good questions that would have been discussed as part of a collective effort to draft those regulations. But that all being said, BG is very supportive of the overarching purpose of the proposed regulations, which is to ensure that occupants that reside in master meter buildings do receive appropriate notification in the event that the building is subject to a possible service disconnection. And so we are very supportive of the overarching purpose. Our comments here were very targeted, given what we know in terms of the deliberations that went into crafting the proposed regulations. I think as through the discourse today, we've seen a lot of good questions asked, further questions by the commissioners. And so again, to that end, we were very targeted in our comments, and we're happy to entertain any questions that you may have.
Thank you. Mr. Trout.
Good morning, Mr. Chairman, Commissioners. I don't want to be here. Much as I enjoy your company, I don't want to be here trying to obstruct or be perceived as obstructing this rulemaking process. But I stand by the comments that we filed and which you've reviewed, in that I believe that the process to date with respect to this rulemaking has been deficient, mainly because when the original rulemaking proposal was filed back in May, it only went to the people who had been participating in the Lynn Hill matter and didn't go to the other affected utilities. And as a result, people whose voices you should be hearing either weren't alerted in time to file written comments, or still may not know that this is going on, because while I tried to reach out to other parties who hadn't received notice before when I served my comments, there's still some, like the munis and some of the very smallest utilities, that I did not serve, because frankly it's not my job to provide notice of a
Mr.
rule.
Trout, the Maryland Register will provide notice at such time when these proposed rules are published.
Yeah, I understand that, and it's to all the parties' advantage to have the draft rules that get submitted by the Commission to the General Assembly for publication in the Maryland Register reflect changes that might need to be made, because after it's been initially published, you can't make substantive changes without going through republication. So you really, from a process standpoint and from a standpoint of moving this along as quickly as possible, you want to get the input that you need before you vote on the original rules that you're going to send to Annapolis. And that's my point. You've been working on these issues, and the parties who submitted the proposed rules have been working on them for 2 years. We nonetheless heard today comments from at least 2 parties, staff and BGE, with proposed additions or changes to the rules that warrant consideration. The commissioners from the bench have pointed out a number of matters I hadn't thought of in the 3 weeks I've had to think about this, that may require adjustment to the draft proposal. For all of those reasons, I think we should come back another day soon, but we should come back another day before you all vote. With that said, there were 10 questions that I asked in Potomac Edison's draft filings. We could go through any or all of those at your pleasure. Some of them have been addressed today, others have not.
Mr. Trout, what do you suggest is soon?
Weeks, not months.
Could you give us a little insight about your ability to track your master metered accounts for both BGE and for Potomac Edison?
We know the accounts that have either self-identified or that over the years we've learned on our own initiative are master metered accounts. We cannot guarantee that we know them all, and that's why I think the suggestion the BGE made, which is if a building owner or building operator wants to be considered a master meter account, they need to tell us. I think that's a good suggestion.
Thank you for that question, and we would answer very in a similar manner. We know what we know, which is to the extent it's indicated in the service application, they answer the question properly. We're going to record it as such. If we visit the premises and understand that it's a master meter account, we will record it as such. But you can imagine, take Roland Park, for example, where there's these old mansions and they could be cut up into multiple dwelling units where we may not know that there are, and it can be as few as one dwelling unit, is the way the definition is read. So you could have an au pair quarter, you could have, a sort of an in-law suite, and it's possible, at least under the definition, it could be defined as a master metered building. So to the extent it's going to be characterized as such, once we know, we know, and then we can record it in our system, and we will treat it accordingly.
So if we delay in moving forward with the regulations, at least going forward in terms of just the publishing side of it, obviously it's going to take a little while to do that, but you currently have some customers that you know of as master metered. Are you moving forward with service denials for those types of customers now? And if so, what type of notice are you providing to them?
So that's a good question. I'm going to actually turn that question over to Mr. Dunn, who can explain our current practices with respect to providing notification to occupants of master meter buildings.
Thank you. Good morning. So we follow normal collection procedures all the way through until we would get to a point of this identification and posting of the building. We actually do field a collector to the property, and these are carefully handled individually. We post the buildings in all of the places I think we discussed earlier that you heard, all entry areas, mailbox areas, all the doors and things of that nature, so we do make those postings. We also know when we're going out on that particular day and who's making that posting, so we get any kind of feedback that we would need from that.
And do you want to also comment in terms of individual dwellings within a building to the extent that we
Yes.
are able to post notices there?
Yeah, so any type of known area where we can post, we will do that. But to your point, there is a risk in that there are facilities out there that will not give the appearance of a master meter account, and there's a lot of reasons. Being a manager of revenue protection, I have the collection field group and theft of energy, and there's, for many reasons, areas where people will occupy facilities and it's not metered individually, and we won't know about those types of things for a lot of different reasons. So that is a risk and a concern for us.
Yeah, so that's a question I have, because, I mean, normally what we think of as a master metered account is a apartment building, for example, and it's got, it's clear that's a master metered account, and that's a commercial rate. Is that correct? Right?
Yeah.
So here we're talking about we're expanding the scope of this regulation, because if we're talking about a master metered account versus a master metered building, it's possible if I rent out the room above my garage and I charge $500 a month and they don't pay any utilities, then in theory, under this, I qualify. So I guess one of the questions, I think perhaps for OPC and the proponents of this regulation, was that the intent? So I'll ask them to answer that when they come back up to the table, or if not, because that to me is, does that apply to one person, so that my tenant above my garage, is this intended to apply to that person? And, is that how you would treat it? You wouldn't be relying on the fact that they had a commercial account as a master metered account, but just that they live in a building that they may rent out their carriage house or their room above their garage.
And that was one of my initial questions when I looked at the definition, the revised definition of master meter building. And as it ties into 7303, I think you indicated earlier, Commissioner Herman, that there may be some confusion as to how the statutory provision, the regulations link up. 7303 deals with submetering and talks about apartment buildings and defines apartment buildings in a way that's 2 dwelling units. So more of your traditional thought as to what an apartment building would look like. I agree the way it's written now, it is confusing, and that's why we only know what we've been told. And so to the extent there is a house that has 2 suites in it, that have kitchens and would be treated as dwelling units, that could be considered a master meter building under this definition.
Right. Okay, thank you.
Mr. Trout, can I come back to you?
Yes, please.
So our notice of proposed rulemaking of July 23rd is posted, right? And you're suggesting that that's an inefficient way of notifying interested parties that we're considering a rulemaking process?
It sometimes works out to be an inefficient mechanism because
So are you suggesting we need a more fundamental change to our notice of proposed rulemaking?
you might want to consider it.
Do you have specific suggestions for us?
Sure. I think, well, first of all, let me explain why I think it's inefficient. I believe what happened here is that it got posted on the banner, the banner that highlights what's going, the most significant recent developments. It got posted on the banner, if at all, very briefly, and then it got supplanted by the next thing that came along. The result of that is that I'm aware of at least 4 utilities who didn't see it.
So this is the same notice of proposed rulemaking that's been occurring for years?
Yeah.
And now, all of a sudden, it's deficient? I'm not following, I'm sorry, help me out here.
Okay. Well, normally the posting isn't the only way parties find out.
So what other ways should we have notified people, and what universe should we have notified in this instance?
There used to be, they used to mail out the notices. The notice didn't get mailed out in this case, at least not to anyone other than, it may have been mailed to the parties to 9444 and 9445, but it didn't get mailed to people like Columbia Gas, Potomac Edison, Smeco, Drop Tank.
My understanding, and that's why I'm probing this, my understanding of our notice of proposed rulemaking is it's a broadly cast notification to the public for anybody who wants to be heard on this matter to come before this commission and speak, and you're suggesting that's not the case, and I'm having a little indigestion over that.
I can only report to you, Commissioner, what happened. And what happened was a bunch of parties that would have to implement these rules when they were adopted had no idea that the rulemaking was occurring. That's what happened. If you believe that that indicates there's an underlying process issue, I would be inclined to agree that there may be something we need to do with the processes to prevent something like that happening in the future. But whether or not that's your conclusion, the fact is that that's what happened.
Yeah, I'm not suggesting that, but I think you are, and that's concerning to me.
All right.
So I'm not sure that there's enough here for me to conclude that our process for notice of proposed rulemaking that's been used for Lord knows how many years is now all of a sudden deficient.
Usually what happens is that a rulemaking grows out of a proceeding in which all the interested parties have been involved. Often what happens is that staff or OPC will circulate the notice to all the parties as soon as it's posted. What happened in this case, because the proceedings that this grew out of involved only the PHI companies and Washington Gas among the utilities. The other utilities didn't get notice.
We understand that, Mr.
I get that. Anybody that is involved in regulatory proceedings in Maryland had to be paying attention to the proceedings of Lynn Hill. So I'm just having a little bit of hard time that folks didn't know these proposed rules were coming down the pike. So I'm sorry. I'm just probing that to make sure I understand what you're suggesting.
Thank you, Commissioner O'Donnell. I, for one, do not see any problems or deficiencies with the current manner in which we notice proceedings. It is incumbent on the utilities to maintain a close eye on notices published by the Executive Secretary's office, whether or not they appear on the banner or disappear relatively quickly. To your credit, you're here, you're participating fully. We have your pleading. At some point in the hopefully near future, we will have the proposed regs, at which time you will have another opportunity fully to provide comment. Do the commissioners have additional questions for this panel? Thank you. At this point, I would like to, if they are in the room, call up the Association of Buildings and the Public Justice Center if they're here, as well as Montgomery County, Maryland, if they are here. I do not see anybody rising for those three parties. We have commission staff who would like to make any opening statement. Oh. Oh, yes, sir. Please, Mr. Francis. Please. Mr. Spievak, if you'd like to get comfortable next to Mr. Francis. feel free.
Very briefly, Your Honors, Exceptional K. Caldwell on behalf
Mr. Caldwell.
on behalf of AOBA. I just rise to say that AOBA supports the proposals as filed by staff. I'm sorry, by OPC and Washington Gas Pepco.
Thank you, sir. Very efficient and brief. Mr. Spivak.
Actually, Mr.
Quite as
Chairman?
brief as that.
Yes.
I'm sorry, excuse me. I actually had one question for AOBA.
Sir.
We did have some parties that commented that some of the utilities commented that they may have some challenges accessing properties to post notices. For any of the representatives of AOBA, is that an issue, or is that something that the Commission should be concerned about?
Well, AOBA didn't take a specific position on some of the comments by the other parties because they were directed to utilities. There could be a problem where AOBA member is an occupant and manager of a master meter department, and trying to get information to either the utility or from the tenants could be cumbersome or difficult. So we'll await the specific regs and offer a comment at that time, but because the comments by BG, I think it's BG and Potomac, were directed towards the utilities, we thought it best not to comment at this time.
All right, fair enough. Thank you.
Thank you.
Thank you. And I'm sorry if I botched AOBA's name. Apartment and Office Building Association of Metropolitan Washington.
Thank you, Your Honor.
Mr. Spivak.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. I will not be quite as brief as AOBA, but I will do my best to to answer quickly here. As noted in our comments, staff is generally supportive of these regulations. We did participate in the cases that underlie the proposals, but we did choose at that time to take a more neutral stance. We have reviewed the regulations as they were proposed. We do support them generally. We had two suggestions that we gave in our comments. Just listening to what was said earlier today, I did want to offer a clarification. With the first suggestion regarding the list of addresses, we were referring only to a listing of addresses, not to one that also included occupants, because we do recognize that the occupants in the building of that type may change with some fair frequency. So, but we did also think that the addresses are pretty much permanent. Once the building is built, they don't change. So that information should be obtainable and can be kept as a record.
So what would that look like, Mr. Trout? I'm confused. What kind of address are you saying that,
In other words,
8600, apartment 101, apartment 102, apartment 103?
I think that's exactly correct, and what the zip codes are. So it's just the building address and the unit numbers, really. And that's simply to have it
How does the
readily
company
available.
know what kind of unit? How do they know whether there's 6 apartments on level 1, or that there is no level 1, that the lobby is level 1 and the gym's on level 2 and that 301 starts? How do they know that?
I think that would be information they would probably have to get either from the building owners or from public records.
So they're going to have to go out and search out public records and figure that out every time for every building in their service territory?
Well, I think somebody said it was mentioned that those records are available from SDAT or from the local property records. So they are available, and as I said, it was offered in the nature of a suggestion, not something that we thought it would be helpful for them to have that information to hand readily if the situation comes up.
I guess I'm sort of, confused by the request, because I guess it's just sort of, if all you're asking for is the unit number, really, and that's just something that I don't even know how would you suggest that they maintain a list of these unit numbers? They keep it in a system that says there's, assuming they could figure out how, that there's 50 units in this building, and there's 5 per floor, and they start on the first floor, and in other units they start on the 3rd floor. I mean, I guess I'm just kind of confused as to what it is they're maintaining, really.
And as I said, it's really a list of the registered addresses for the building, I think was what we had in mind.
Registered addresses. What registered with whom?
generally with the post office. And my recollection, for example, is that the post office used to publish ZIP +4 guides that actually literally list every address within the community, including the units within a building. And that was so that people could find those extra 4-digit zip codes. And
So-
I think that information is still, I think now they have that online.
So wouldn't that be picked up, Mr. Spivak, by 06B1 that says that the postal address is readily available? I mean, I think that if the postal address, if it's as simple as that, that seems to me to be, that parties could argue that that's readily available. It's, there's a source out there at thepostoffice.com where you can go and find, and you could just mail a letter to the occupant, and therefore that would be potentially or arguably readily available, right?
I think that's correct.
So maybe your list, because it obviously has some questions attached to it, may be picked up by B1?
It might actually.
Okay,
I think that might cover it.
okay, thank you.
So, with respect to staff's second suggestion regarding notifying the Office of People's Counsel and OER and the Social Services Director of when notice has been provided and the form it took and the date on which it was provided. I did take a stab at drafting some language for that. As I was watching this, and I can certainly read that into the record. It may still need some additional work, but we'll give it a try. And that is adding a second sentence to paragraph H of that regulation that would say, upon notifying the occupants of a master metered building of a pending service termination,
On notifying the occupants.
of a master metered building of a pending service termination, a utility shall provide the Office of External Relations, the People's Counsel, and the Director of Social Services with documentation of the date notice was given, the form of notice given, and, if posted, a list of the locations in the building where notice was posted. And clearly, if as it was suggested earlier, that the Office of the Attorney General Consumer Protection Division needs to be added into the regulation, that would be added as well.
Thank you, Mr. Spivak. Do the commissioners have questions of staff counsel? Why don't we take a 5-minute break at this point? We'll come back. It's my intention that we'll do a page turn regarding the red line edits. I should ask if there's any other parties that I did not identify. Yes, ma'am. Please approach the podium and identify yourself.
Yes, my name is Shirley Bardis Hassan, and I'm representing Columbia Gas today. Actually, I'm not representing them because I'm not an attorney. I'm here on behalf of Columbia Gas today. And Columbia Gas, like Potomac Edison and BGE, were not party to the discussions behind these proposed regulations. We do have some concerns, although we support the purpose behind the regulations, and I think back to RM57, which Commissioner Linton was involved in his prior life, and RM57 addressed these same regulations, and in that scenario, we had working groups, and all the utilities affected by the regulations, as well as any other party, was welcome to participate in the working groups. And we worked through the regulations together, and in some places we came to consensus, in some places we didn't. But you didn't have this, you didn't have to debate it out through the rulemaking sessions as much as it seems like may be necessary in this scenario. So I would suggest that OPC create a working group so that other utility companies and interested parties may participate and have their voice heard in the working group.
Thank you, Ms. Hessen. Any questions?
Yeah, quick question for Columbia. How long do you envision we would need to take to do that? And let me tell you why I'm asking this question. If parties have not been able to be part of this process as robustly as maybe we could have, and if the commission decides we want to head in that direction, I'm not sure that we will, but if we did do that, we still want to endeavor to get these rules in place before the winter cold season occurs. So I don't want this to drag on another year if we're going to approve these at all. So help me out with how long this process may take for Columbia to be satisfied.
I think it could be done expeditiously, since the regs have already been proposed, so we already have something to start with. It would also depend on how often the working group meets, and maybe initially the working group can decide how many times they want to meet so that it doesn't drag on. I understand and I recognize your concern to get this done before the winter heating season. And I think that the working group could work within those boundaries to make that happen.
Right, because rulemaking, notice in the register, and all the subsequent processes that have to occur are lengthy already. And now we're talking from two utilities who I think are in general agreement with the thrust and the purpose of these proposed rules, saying, whoa, let's slow this train down. Well, that's concerning to this commissioner. So.
Right. I understand. I'll also note, too, regarding your concern about the utilities not knowing about the rulemaking session, I've been involved in regulatory work since 2005. This is only the second time in 13 years where Columbia wasn't notified when there was rulemaking occurring. So it is, I think this was a unique circumstance, as Mr. Trout pointed out, where this rulemaking session resulted out of settlement agreements from a specific situation. I don't think that's the traditional nature of rulemakings. Obviously, we'll more closely watch the official filings, although on the Commission's website, although that gets pretty that becomes a pretty exhaustive list. If you are looking for suggestions on a better way to do that through your website, I would suggest making a special place to look just for notices, so that parties who are interested could focus in that specific area to find things that they might want to participate in.
Thank you.
Mm-hmm.
Thank you, Ms. Hassan. Any further questions of Columbia Gas? Seeing none, we'll take our break, but my intent is when we come back is to begin a review of the red line language. If my colleagues have any questions or concerns, we'll take them at 11:45. Recess until 11:45. back on the record. At this point, the Commission plans to, after hearing the comments this morning, take a look at the proposed COMAR changes that the settling parties provided in attachments B1 and B2, and propose changes based on what we've heard and the comments that we've received. So why don't we start with B1? And I'll ask the commissioners if, would you find it helpful if we brought the settling parties back to the table?
Yes.
Why don't we do that? If the three settling parties could be seated again at the table. We lost Mr. Hayes. Okay.
Mr. Chairman, we might want to invite, as we go through these specifics, any other comments from interested parties as well.
That is a great point, Commissioner O'Donnell. To the extent other parties would like to have a say as we proceed with portions of the proposed regulations that affects them or their interests, they may approach either of the two podiums. Let us begin with COMAR proposed regulation in attachment B1, which is COMAR 20.31.1.2 definitions. Noted earlier, Commissioner Herman proposed a change to item number 13.
Right. So I think that we could change it to payments. Where is our change it to as part of rent, condominium fee, or other charge, or as charged under the authority of PUA 7-303. Just to be clear.
Thank you. Any objection from the commissioners? Seeing none.
So could I ask a quick question of OPC? Did you intend, you heard me earlier, I assume, did you intend that this would apply to me if I have somebody living above my garage?
So the intent was to certainly make it as broadly applicable as possible, but
yeah.
Sorry. The intent was to allow applicability to as broad amount of defined master meeting buildings as possible. But we do note your concern in the ability of the utility then to know if you are indeed renting your upstairs and providing that service charge. So we see that as a possible concern. So I think that would be a fair carve-out of this definition.
Any ideas how to do that?
In attempting to just talk this through with the other parties, there was some possible resolution of, so we'd have to make sure that this works with the utilities' billing systems, but if their master metered accounts are coded as commercial, maybe infusing commercial customer into here, we'd have to make sure that, so that was just a resolution on the fly. We'd have to make sure that properly.
So you would be comfortable with having these regulations be applicable to master meter apartments that take service as a commercial customer?
Yes, I say that hesitantly. Again, ideally it would apply to maybe a little bit larger than just having your upstairs rented out. Maybe it's a row home in Baltimore City that or maybe a number of row homes that have become now sublet as they could fall under this definition. But I think we would be comfortable with that change if that provided additional clarity and made things easier for the utility to be able to understand who their customers
Who
are
we're
that
talking
fall
about here.
into this particular definition.
Mr. Spivak?
Another suggestion, maybe. I'm trying to remember where in the regulations it does this, but at some point it differentiates buildings by the number of dwelling units in there between a residential and a commercial customer. So maybe you might have, for this purpose, master metered building does not include buildings with 4 or fewer dwellings, or maybe 3 or fewer dwelling units. That'd be one way to.
Anybody else? Any of the utility
out.
companies have a comment on what might be an appropriate designation?
Well,
Damon Krieger on behalf of BG. I mean, the statute, the Public Utilities article, does define apartment house as more than 2 dwelling units. So, to the extent you'd want to be consistent with the statute, you could
Okay.
consider defining in that way.
More than 2. Okay. Anybody else?
Would be perfectly acceptable with that.
So, just to, if we were going to do it right now, could we change it to master metered building means for purposes of COMAR, blah, 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 a building with 2 or more dwelling units? Or is it more than 2, Mr. Krieger? More than 2. With more than 2 dwelling unit or units? Anybody have a comment on that?
well, that may pick up in the case of a residence if there are multiple subtenants within a home. Does that mean that would become a master metered building?
I'm not sure what you mean by multiple subtenants.
If a homeowner leased out several rooms in his or her home, does that become a separate unit?
Well,
the
in
home?
theory, at least we're narrowing it down a little bit, Mr. Hayes. I'm trying to, to make it more clear here. And
There were
if
good
we're
questions this
consistent
morning.
with the statute that says more than 2, then perhaps that is a reasonable start. I don't know if any of my colleagues have a comment on that. Mr. Trout?
I think the other solution that you propose, which is keying this to the type of service, commercial versus residential, might work better. I can't say for sure because I haven't been able to consult with my client about the suggestion, but I think that might work better. And I also think it keys in more closely on the cases that were the cause of the rulemaking.
Well, I'm going to propose to my colleagues that we start with more than 2, and then in our next notice, we can talk about whether or not commercial is a better option.
So, Commissioner Herman, can you read your proposal?
It is master metered building means for purposes of COMAR 203101, COMAR 203102, and 203103, a building with more than 2 dwelling unit or units where the customer buys.
My opinion, if you're interested, is that is an improvement over the existing language, because the existing language is deficient. It says a dwelling unit.
And that's where I'm trying to get to.
So I would support that.
I would support that too. Also, I like that it's consistent with the definition of apartment, so we have some kind of basis. So you got my support on that one.
Thank you. Seeing no objection.
Just one clarification, Your Honor. Again, Central Caldwell on behalf of AOBA, and perhaps this is a question better suited for the utilities. With that definition, can you be a master metered apartment or a master metered dwelling and receive residential service? Are they synonymous? Or if you're a master metered account, do you automatically become a commercial customer, or no? Okay. So you can be master metered and receive residential service, residential rates.
Yes, that is correct.
Thank you.
Yeah. Commissioner Linton.
Yes, Mr. Chairman, I'd like to propose that we change the phrasing of this would be line 3 of section 13 to, instead of saying either as a part of the rent, say as part of a rental agreement or a lease.
as part of the rental agreement
or lease.
or lease. I support that. Any objection to that edit? Seeing none. Are there additional proposals to this section or this chapter of COMAR?
If I may comment, I like the suggestion of more than two. However, it does give me concern. When I look at our tariff, we define master metered or group metered apartment accounts as having 4 or more units. So I'm concerned that we may sweep up accounts here that we have no idea of whether they're master metered or not. I mean, if we go to either describe it as a non-residential account, commercial account, or more than 4 units, that would help Washington Gas. I'm not sure how that would impact other utilities, but I'm concerned about capturing situations where we have no idea of knowing whether an address is a master metered account or not.
Okay.
I think portions of the low-income assistance programs in the state of Maryland in the Public Utilities article define it as 4 or more for the purposes of multifamily housing assistance or programs. So including maybe Empower and some other things. So we might have an inconsistency here in various parts of the code.
Right. So, what was your language, Mr. Hayes?
4 or more, having 4 or more.
4 or more?
So simply just changing 2 to 4. Is that right?
Well, I thought it was more than, or yes.
4 or
it's
more.
4 or more.
Okay, Commissioner Herman, do you support that change?
Yes, at this time, I think 4 or more is I would support that.
Okay. So it would now read a building with 4 or more dwelling units. I don't think we need unit.
Right.
Yep.
Okay. Any commissioners objecting to that? Seeing none. Any additional revisions to this chapter? Seeing none, we'll move to attachment B2, which is chapter 3, regulation 6. This is where the fun begins. Do commissioners have any questions with regard to part A? Questions with regard to part B, 1 or 2?
Yes, Mr. Chairman, I have a suggestion for B1. I would propose removing the word all. My intention is to require that the utility do both of these as opposed to just one. So if they have the information in order to do both of them. The goal is not to have it so that utilities just by default always do B, just as an example. So what it would read, the way it would read is to say individually notify occupants. So we'd remove the word all, and because they may not know of every occupant in the building. And then under section B, instead of having the word and, you just have the word, excuse me, instead of the word or, you'd have the word and.
Can I voice a concern, Commissioner, with that? If we remove the word all, a utility could satisfy this requirement by notifying a very small subset of the occupants, and I know that's not your intention, but it would read that way, and I'm a little concerned about that.
We would voice the same hesitation, Commissioner. If all's removed, technically they may not know all of the all of the addresses, send it to some, but then also not necessarily post door hangers or stuffers for all tenants. Hopefully that's not the case, but it could conceivably read that way.
Utilities.
Yes, Mr.
Krieger.
Mr.
Krieger. Mr. Krieger, thank you.
Thank you. So with respect to the second, I don't have a comment with respect to the removal or inclusion of the word all, but to the extent that commission would consider making this an and proposition, meaning satisfaction of both, that would be a concern to BGE in that the overarching goal here is to ensure proper, reasonable notice to the occupants. And our current practice provides notice to the extent we have access to mailboxes, entryways, exitways, in each individual occupant apartment or condo. We'll go to the door, we're going to do that door stuffer, we're going to do whatever we can to provide notice. A mailing, as has been indicated earlier, is not something that we necessarily have the information to complete the mailing. SDAT, I know that's been thrown around. SDAT is an ownership database, so it's not going to reflect individual units within a rental building, right? It's going to say who owns the building. It's not going to say, there's 20 units within that rental building. It'll just say the owner. Now, the post office, I'm not aware of Mr. Spivak's suggestion about going to the post office and looking for a book of addresses. But right now, if the goal is to provide reasonable notice to occupants, we think the or proposition would satisfy that overarching goal, and that the additional requirement to provide first-class mail notice really would put a burden to the extent, frankly, that I think the utilities would have a hard time meeting, particularly if the word all is going to modify occupants. If the goal is to try to send notice and post everywhere in the building, it feels like that's more than sufficient.
Thank you, Mr. Krieger. Commissioner?
Yes, Mr. Krieger, the language that's still included here says towards the end of the first section A is if the postal address is readily available to the utility. So does that address the concern the company has regarding removing all? The intention here is not to make sure that, not to require that you provide it, but if you have the information or if it's available, that you would send the notice through mail.
I think our position would be that we think the posting provides reasonable notice to the occupants. And, obviously, posting a premises is beyond what we would do for any other customer, individual residential customer. We obviously have, for the last visit, things like that, but we don't go plaster every exit and entryway to a residential building. So we think this provides reasonable notice. And again, the goal will be to put a door stuffer, right? So every single condo or apartment unit is going to have an individual notification. So that's, in our minds, tantamount to a mailing. And so it would be duplicative, and we think it would be difficult to satisfy A. Although it's a good alternative to the extent that we can't, we're denied entryway, right? So to the extent that the building owner says you can't come in, puts padlocks on the door, or whatever it may be, then we would default to A, and we would do whatever we could to provide that first-class mail notice.
Commissioner, does your proposal stand?
Yes, I still think this is a fairly reasonable proposal. And it's only required if the company has access to the information and it covers us in situations where, as was mentioned a few moments ago, if the landlord or owner of the building is unwilling to allow the company in. You're talking about instances of days here. So where the company doesn't have to ramp up to send everything. It's already part of their process to do it automatically. So it doesn't matter if the utility shows up at the door and the landlord says you can't come in, there isn't a requirement to go back and start making letters or postcards, but because they're already on mail. We have other deadlines here of 20 days, and there's different termination notices or time is of the essence. So I think it's a bit more efficient that way, as opposed to the message having to cycle back to the company that the landlord wouldn't allow us to post the notice while the timelines for service denial are running.
If I may speak up, I would second what Mr. Krieger said for Baltimore Gas and Electric. I can see where down the road, if the requirement is that we do both, presuming we have, if the postal address is readily available, that may raise arguments that, well, you should have been maintaining that over time. You don't wait till you have the need for it to go out and try to find that kind of information. The addresses behind a master metered account are not something that we have available to us, and we would have to go out and search for it. I mean, might be interview residents of the building, how many units are in the building. I mean, it's just not something that we can get access to, I do not believe. And I'd hate to have to fight the argument in the future that we didn't have that information, but we should have, so that we didn't give proper notice of termination. If we have to fall back to that, we can certainly do that. That would be an alternative. But posting on every door and on every entrance to the building, in common areas within the building, that seems like it would provide full notice of the impending termination.
So wouldn't the concern that you could have some liability in the future because the company didn't have access to this information support more the concern that there would simply be a default to Section B?
Well, I'm not sure we have the ability to track this kind of information. The units, the unit numbers, it's just, I don't believe that we could do that now. We'd have to build a system to keep that kind of information.
Sure, Lynn, I would also argue that B is probably more indicative of being able to provide notice to a resident than A. I mean, we get a lot of mail, a lot of junk mail, a lot of times it's thrown to the side, whereas if there's a notice plastered to your door or stuffed in the mail slot, to the extent you have a mail slot on your door, that's going to give you more. That's going to give a higher likelihood of receiving actual notice than mail. So I think it's a reasonable first step for the utilities to take. And of course, there's the waiver provision. At the end of the day, to the extent we can't complete either one, if denied access, then utilities can't terminate until they would seek a waiver.
Mr. Trout and then Mr. Spivak, briefly, please.
Thank you, Mr. Chairman. I have two comments on B. They key off of the first and the third of the questions that I posed on page 3 of Potomac Edison's comments. The first question relates to the language that's added with respect to postmarking the notice to occupants not less than 20 days prior to the proposed date of disconnect. Our systems were all built on 14-day notice. Especially if the Commission's going to adopt Commissioner Linton's change, which would then provide 3 separate forms of notice to the occupants. There's posting the building, doing the individual door stuffers and flyers, and mailing them a notice. The third of those, the mailing the notice, really is belt and suspenders. And rather than blowing up our existing systems and having to figure out how to change 14-day terminations into 20-day terminations, I would respectfully recommend that the Commission change the mailing deadline to 14 days rather than 20. Again, especially if they're going to entertain Commissioner Linton's suggestion, which we don't otherwise object to. That's the first of my 2 points. We can talk about that, or I can make my second.
Is it relevant to what we're discussing?
The second point
Yes.
is also relevant to what we're discussing here.
Please.
The second point, again, with respect to B, is we're going to have to build a system to store the addresses if we're going to mail the letters. We're going to have to collect, store, periodically verify, and then be able to generate the letters and send them out. Is the Commission planning to add to these draft regulations some time for the utilities to be able to do that? at least the utilities that aren't already parties to the settlement, and so have presumably been thinking about how they would be able to do that. I would respectfully recommend that you do build into the regulations in terms of the effective date or otherwise implementation time. Those are my comments on B.
Thank you, Mr. Spivak.
Just a quick editorial note in that section 1, where you have the or disjunctors, you have 2 ors there.
Yes, we noticed that typo. Thank you. Commissioner Linton, what is the proposal you are laying on the table?
I think it remains the same. Well, I know it remains the same. One of the primary questions that was raised during the Lynn Hill situation, unfortunate situation, was the challenge that was presented by the customer and some of the occupants, and ultimately by the Attorney General's office, that notice was not appropriate and was not received by the parties there. Our existing regulations required posting of notices, and there was not a situation there where parties were, or the utilities were prohibited from accessing the building. So we're talking about a more involved situation here where a landlord or owner of the building would prohibit the utility from accessing the building in order to provide notice. So my concern is that there would be, because of concern that they would be unable to access address information as it's currently written, that there would simply be a default to the process we have currently, which we've already seen as having had some challenge with the prior experience. So by suggesting and by modifying the section to remove the word all and to include the word and, but leaving the option of having including so that it says service if the postal address is readily available to the utility. That gives us an additional piece of cover that we didn't have in Lynn Hill. Otherwise, we're adopting a regulation that basically looks the same as one that we've already seen get challenged by by utilities, by consumers and by property owners.
Thank you, Commissioner Linton. I see your concern, although I also recognize the issues and burdens that the utilities have mentioned. Therefore, I would not support the proposal to the extent that we are replacing or with and. Other commissioners?
I do support the proposal. I think we want to make sure we do everything we can to provide notice, and I think you've added enough of a disqualifier. If you can't, the address is not readily available, then there's the waiver provision. So, and I also note that SDAT, at least for the Lynn Hill situation, you could get all those addresses. So in many cases, there is publicly available information that would be readily available to the utilities to be able to do that mailing. So I do support Commissioner Linton's proposal.
I do not. I'd like to expound upon why I appreciate the intention of the proposal and Commissioner Linton, but one, I think removal of the word all allows that section of the provision to be satisfied by some. And I don't think that's the intent. I think that comes under the heading of unintended consequences. Additionally, I do not support the removal of the word or and supplanting it with and, because the current regulations are or. And when we finally got notice to the turnoffs in Lynn Hill, they were done under the current regulations, which were completely sufficient and adequate to provide that notice. Now, this case was high profile and had been in the news quite a bit. I understand all that, but I don't see the deficiency in this particular part of our notification process that would require dual notification, both posting all over the place and the added cost and burdens of mailings, multiple mailings, maintaining databases with addresses. That's going to be required by changing that one word or to and I don't support that.
Commissioner Herman.
Last, huh? Okay. So, nor do I support it respectfully. I'm concerned with the ability of the companies to be able to maintain these kinds of lists, and I do think that the somebody posting something right on your door is probably the best possible notice, and so if that's an option, I support that, and I'm concerned with the extra administrative work that and cost to the companies that this could require. So for that reason.
Thank you. The proposal does not pass. We will note the typo with the 2 ors regarding Part B.
Mr. Chairman, I have another proposal in this area.
Commissioner O'Donnell.
I'd like to propose we change 20 days to 14 days as requested by Potomac Edison.
For good cause shown, I would support the change from 20 to 14 days. Commissioner Richard.
Just so I understand, we're doing this because of the request of the company. My concern right off the top of my head is that it would take a few extra days for the mailed item to be received. So to ensure that the recipient, the occupant, has the full 14 days, it seems like it would be good to have those I guess buffer days. So and I mean the assumption is everyone's going to see whatever's plastered on their door. I think there are circumstances that you may actually see something posted first, but anyway, I think my position is I'd like to leave it at 20 days.
My purpose in offering, not just because the company suggested it, but it makes sense to me to be consistent at 14 days. That's been the traditional notification time period for these situations, and an inconsistency may take a while to get straight and could provide, as in the case with Lynn Hill, additional challenge avenues. I just think it's easier to simplify and keep it straight and not complicated. So it's the KISS principle for me, keep it simple.
Commissioner Linton.
I think that there's some benefit to having it at 20 days. I understand the rationale for keeping it in line with 14 days in other places, but I actually would agree with Commissioner Richard that the purpose of receiving it, once you do receive it, is to have some time to take some action, and it's postmarked 14 days prior. But these tend to be, mail doesn't always travel as well as it should in these situations. I mean, as we saw with Lynn Hill, there was a number of other challenges at the property address at the time, and the notices weren't always reaching the occupants or the owners as quickly as they needed to. So that people would have the opportunity to take whatever action they needed to take. I think the 20 days is the longer time period is a better time option.
Thank you. Commissioner Herman, again, breaking a tie.
I would, I think I would vote to keep it at 20 days. I think that it's, I understand that the companies, trigger everything off of their 14-day, rule, but if you're going to have to create a new letter, then you can put any time into your system that you like with respect to that letter, and I suspect and I believe that when you're looking at a master metered account, this is not something that all of a sudden just pops up as a surprise. There's been a lot of discussion and notification, and I don't think that the notice, I'm hopeful that it won't cause significant problems for the companies.
Thank you, Commissioner. 20 days notice stands, and yes, Miss Hassan.
Yeah. Yes, for clarification purposes, the way I'm reading the regs is now we're going to be noticing the tenants about the pending termination before we notice the customer of record. Is
Because
that
you notice the customer record in 14 days, is that right?
Correct.
Right. I think that would be the effect in this case.
Let me ask you another question while you're at the microphone. What kind of, how do we notice single residents for cutoff?
It's 14 days.
14 days. That's why for consistency's sakes, we're going to treat this class of ratepayers, they're not even ratepayers, they're tenants in a master meter building differently and with more leeway than we do everybody else in the state. And I'm opposed to that notion.
So just to be clear, the tenants would receive notice before the landlord by 6
Correct.
days.
If you're notifying the tenants at 20 days, the landlord doesn't get noticed till 14,
Thank you.
or the property of the customer of record.
Well, I'm sorry, just to be clear, this is a first-class mail, so they would receive a notice assuming you have the address. So if you're mailing it to them postmarked 20 days in advance, once it goes through the mail process, I guess I don't know how long it takes, a couple days for it to go through the mail, a couple days to go through the condominium association's mail system for the consumer to get it, or excuse me, the occupant to get it. You're going to be right in that same day or two, perhaps.
But
period.
don't we also send by U.S. mail the notice to the customer of record? Yes.
Yeah.
Yes.
So then you're still having
Well, yeah, but the customer of record will have received this should not be a surprise to them at this point. I mean,
understood.
By that point, that customer of record will know that the termination is, the time's up, basically.
And in terms of our discussions, that was exactly one of the rationales why we proposed 20 days, was because, especially with larger customers, they would certainly be aware via bills or notices or communications with the utility that...
I just think it's a strange outcome that the occupant, the tenant, will get official notice before the customer of record of the utility.
There's not even a relationship between the occupant and the utility. And yet they're going to get notice before the customer of record does. That makes absolutely no sense to me at all.
Well, that was sort of my understanding of the systems, is that the customer will have had multiple notices prior to a notice of disconnection. They're going to have late notices, and they're going to have multiple, they're going to get different, they're going to get a lot of notice before, the notice of termination is not the first time that somebody's under threat of disconnection, is my point. I think that there's a lot of other notices, which was why I was comfortable with the 20 days, since the companies were also comfortable with the 20 days.
And that was my understanding too. I mean, at this point, it's the occupants who may be completely in the dark at this point. Well, they are about to be in the dark if they don't get notified, and so and they're the ones who likely may have to relocate and take all kinds of action. So, to the extent that they can have at least that 14-day notice, I think it's important we give them that full amount of time. So.
We're going to have, is OPC going to later try to change the regulations with regard to other residential ratepayers notification?
I have...
Why would we treat those citizens, that class of citizens, differently?
I have no specific
Never mind,
intent
it's
of where the
rhetorical.
office would go.
Moving on to Part C, we've heard two proposals laid forth. One is to delete the word safely comply, which I support, since any waivers would come back to the commission in an administrative meeting. The other proposal was to reduce the waiver request action before the commission within 60 days to 30 days. I understand that the settling parties do not oppose the shortened period to 30 days. For the reasons discussed earlier, I would set forth proposed revisions to those two items.
I agree, Mr. Chairman.
I don't want to be last.
I agree.
I concur.
Mr. Richard?
Yeah, I agree too. We discussed a little bit about the role of the Attorney General's office. I don't know, I'm just throwing this out. Should we be specific here that one of the steps we would expect before such a waiver is that the utility had, not exercised this as their first remedy? That given that the law does say that they have the right to go into the premises, that they should seek the ability to do so with the Attorney General's office or other law enforcement. So that just occurs to me from our conversation a little bit ago. And if that's the case, would this be the appropriate section to put it in?
Commissioner Richard, my recollection of our discussion of the Consumer Protection Division of the Office of the Attorney General was notification along with the other agencies, which makes sense to me. But putting them in the process in this section of the code, I think, is a great complicator, and we better be careful about doing that here before we have some discussion with the Office of the Attorney General.
Okay.
Because I haven't heard from them on that matter.
Yeah, no, I agree. It's probably a good idea not to surprise them, but I would think that should such a waiver come to us at some point in the future, it would be good to know that all remedies have been exhausted before a waiver is sought. So I will withdraw that idea.
Commissioner O'Donnell, did you vote on my proposal?
I did.
You did? Okay.
I said I concur.
Sorry. Thank you. Any other edits to Part C? Seeing none, we will make those two edits to remove the word safely and to change 60 days to 30 days. Part D, I propose one edit as brought to our attention by Potomac Edison. First line of Part D, I would change at most 1 day to at most 1 business day. Any additional?
Mr. Chairman, I just think for just to be a little bit more clear, just if the utility seeks a waiver under C of this section instead of from B1 or B2. Oh, wait a minute, I'm sorry. So, yeah, because I'm confused as to, is there a reason why it says B1 and B2 and not C? Because C is the waiver. So if you're asking for a waiver, you're really asking for the waiver under C and not B1 and B2?
I see that, yes. We could likely delete B1 and or B2 from Part D and replace that with
Under C.
C.
Right.
And make paragraphs singular.
Just a minor point of clarification, maybe then instead of this section, seeking a waiver
Right.
from C.
From C. Waiver from C.
Waiver from C, right.
Yes. Okay. Thank you, Mr. Raker. Commissioner Linton, did you have a comment?
Excuse me, Commissioners, you're not seeking a waiver from C, you're invoking C. So you're seeking the waiver under C.
Under C, yes.
Sorry.
Thank you, Mr. Trout.
Thank you. This is a group effort here.
And we got the S coming out of paragraphs, right? It's just paragraph C. Is that the suggestion? Paragraphs is currently plural because it says paragraphs B1 and B2, and I'm suggesting it's now just going to be singular, paragraph C.
Yes.
Thank you.
Any other edits to Part D?
I have one, just on the comment that Commissioner O'Donnell just made, where paragraphs, I believe that's supposed to remain B1 and B2 because it reads, all the utilities' efforts to fully comply with paragraphs B1 and B2.
Okay, so that's not addressing the waiver? Is that right?
It is.
That section there that I was talking about is not addressing the waiver section?
Well, so it's addressing the
Oh,
utilities.
it's addressing the requirements in
Compliance.
In
okay,
B1
I
and
got
B2,
you.
yes.
I'm with you
Yeah.
now. I got you.
Okay.
You're right. I'm sorry. I stand corrected. Got it.
Any edits to Part E1, E2?
Oh, sorry, Mr. Chairman. The question I have to my colleagues is whether it makes sense to change premises in E to master meter building. If there's a,
E1?
it would be E1, E3, In E6, I'll use premise.
I see no objection there. I believe the intent was to make them synonymous. So changing premise in E1, E3, E.
6, it's on the third line from the bottom. I think I caught them all.
Yeah, premises is actually a defined term here. I'm just checking. I don't know why. I don't know what it's supposed to be for. I don't see I'm not objecting to the proposal. I don't see a concern with it. I just wanted to make sure we're not removing it where we should. I'm not sure why we still have it now.
The definition of premise means a building or portion of a building that is receiving service from a utility for use in a dwelling unit or units. I don't see a conflict in this case. I see additional specificity.
I agree.
Any commissioners object to this change?
No.
Seeing none. Any proposed edits to E2, E3, E4, E5? I have a proposal for E6. We discussed this earlier. Currently, it reads, a statement that the occupant should contact the customer of record for the master metered building to discuss any applicable rights. I would strike most of that first clause and change it to state a statement that the occupant has applicable rights. Removing the customer. Any concerns from the bench? Mr. Krieger.
Mr. Chairman, I apologize, but going back to the premises versus the master metered building, just to clarify what I think is probably the intent of use of that term here, although again I wasn't party to the discussions. It's possible it could be a master meter building that is, and the master meter is just servicing the elevators or the common area lights, and so you could theoretically have service subject to termination for those common areas, the elevators, but the individual units could be on separate meters, and so the building is not necessarily going to be shut off, but the elevator tank and the common areas could be shut off. So I think that's probably their intent in using the word premises, but I could be wrong.
Thank you for complicating this.
I apologize for complicating it, but we're talking on the fly here.
Right, and that's why I asked. I was just trying to be really clear. Is this? When I asked Mr. Raker specifically, did that intend to be something that might not be the master metered building? So you're saying that these provisions would apply in the event that each individual unit pays their own bill, but that the building might get turned off, in the elevator and the common areas could be disconnected.
That would be a question I would raise. It would seem to me that would fit within the overarching tenure, which is, if you're going to terminate you're turn service off for the elevators and all the lobby area lights, and could be the heating for the building, but not the lights in the individual units, right? You could have common heating throughout the building, it's master metered, but not necessarily have each unit could still be on a separate meter for other electricity. So
thank you.
That's probably the difference. But again, I defer to the petitioners.
Commissioner Herman, do you wish to revisit, or we let the vote stand?
I think that perhaps by using the word building, it would still apply potentially to the, whether it was the whole building or part of the building. I think it would probably still apply. I think you'd be hard pressed to say it doesn't count because it only applies to the elevators and the heating system. So
I don't necessarily disagree with you. I'm trying to explain what may have been the rationale.
Right, and since the discussion was that they intended it to be that way, I think I would just let it stand and see what it looks like when it's all put together. Thank you.
Okay. Oh, sorry, Commissioner Linton.
Yes, thank you, Mr. Chairman. I actually had another question. about 6C.
I don't think so.
This 6C is in reference to the serious illness and life support provision of COMAR, which requires, which authorizes or prohibits service denial when an occupant of a premises has a serious illness and the termination would aggravate that illness, or if they have need for life support equipment, etc. Without going too deeply into this particular regulation, because there's a lot there, I'm curious as to, under 6C, how many recertifications can be requested by the occupant before the utility is able to move forward with some type of posting and service denial. Was there any discussion about that?
So we discussed some concerns where maybe that could be gained for some reason. The intent of drafting this was to align with 2031-0301, which does not include a specific amount of recertifications, but the utility can seek commission approval to terminate if they deem that too many certifications have been used in a particular instance.
Well, and that's, I don't want to go too far into this. It might be something that needs to be thought through a little more, but the purpose of this section of the regulation and the requirement in the utility and the reason for that 30 days is to require and allow the parties to work out a payment plan for the outstanding amount due. So this is not a receive service for extended period regulation. It's more so intended to give that consumer with a medical challenge an additional opportunity to work with the utility company to resolve the debt so the service can stay on. So in this case, an occupant is not required to pay the bill for the master metered customer. So I'm just trying to understand what would the process be, and that's why I said this is I understand this section references this portion of COMAR, but it's there's a lot in there. So if this is intended to last for extended period, I mean, there's 20 occupants with different medical conditions. This could last a while, depending on how the certifications come through. So I'm just trying to understand what the thought process was and what the long-term approach would be.
So we did consider that, and rather than building in a additional complicated process possibly in here, we referenced 0301 with the thought that under subsection F, the utility could request commission approval to terminate. So in this particular instance, if it happens for many periods of 30 days, however you define many, the utility can come in and seek guidance or seek permission to terminate if for some reason that process is being taken advantage of.
Commissioner Linton, do you have a proposal with respect to C?
This is I understand the intent here. I'm supportive of the intent. I just think that there's even just for regular residential customers, this is a challenging regulation. For utility consumer advocates, etc. I think it's complicated when you have occupants who are not customers, who are not responsible for the bill, who are able to obtain protection under this. I'm reluctant to make a recommendation here, only because if I do, my recommendation would be to remove that section. And I understand what is intended here, but it's going to be a unique situation with every condominium or master metered account that ends up applying under this. Looking at Lynn Hill as an example, since that's the fact pattern that we're familiar with, there was none of those tenants could have paid the outstanding bill. Even the condominium association couldn't pay the outstanding bill. So there wasn't going to be a negotiated resolution there. It would have just been a delay in the service denial for consumers who certainly needed the time and would like to see that they have that time. But there has to be at some point a resolution to it. So maybe, and I'll just throw it out there as a suggestion, maybe that maybe there's a limit on how many times a certification can be renewed.
So we did, again, toss around that possibility, didn't incorporate it here, and simply mirrored the provision of rights as they currently stand in COMAR, and this subsection would, subsection 6, I mean, would basically just provide information to the occupant about their rights as they currently exist. So, I do hear your concerns, Commissioner.
Yeah, but it doesn't just do that. It also conveys a right to the consumer. It doesn't just provide notice. I mean, because they can provide a certification that prohibits the service denial, that's actually an extension of a right to the occupant.
6. I thought you did.
Well, our
First sentence.
our reading of 0301 subpart E was that technically one can meet, an occupant can recertify for an additional 30 days or thereafter. But we certainly hear your
right.
concerns.
I mean, again, that's why I said this is a very. I understand the rationale here, and like I said earlier, I'm supportive of the rationale. This regulation wasn't designed for master metered accounts. So, I mean, this is obviously a situation where, their family is living in a residential home, and one of the members of the family or tenants, somebody else living in the house, has a medical condition. But in this case, you could have multiple condominium or apartments with multiple individuals that could have medical conditions. And it just, I'm not sure, the best thing I could come up with right now at this point would be to provide some type of limitation on it, but I don't know if that's a heavy-handed way of approaching it or not.
Commissioner Linton, would you like to make a proposal?
Okay. For Section C, I would propose that we say that after initial delay, certification may be renewed not more than twice to request an additional delay by providing another certificate to the utility.
Okay, 30-day delay.
Mm-hmm.
Okay. So you're saying renewed only once?
Renewed only once, correct.
So we're inserting the word once after renewed?
I thought it was not more than twice.
I'm sorry, Mr. Seeger.
It'd be 2 times. So you get the initial one, and then you could renew one other.
So maybe renewed once.
One additional
delay, okay. I could support that.
I'm supportive. I have, after we're done with this issue, though, I have a more fundamental problem, I think, if you're not.
Okay. With respect to Part 6? Yes. Okay.
So we haven't voted on yours.
We haven't voted on mine yet, so we have mine, we have Commissioner Linton's, and Commissioner O'Donnell has more to add.
What was yours, Mr. Chairman?
Mine was to amend the first part, so it says a statement that the occupant has applicable rights. I removed everything regarding the contact with the customer.
Okay. I was not paying attention.
That's quite all right.
That was what I was going to add.
Oh, okay. That was what Commissioner O'Donnell had. Any additional edits or proposals? Seeing none, the new statement will read in part. Part 6 will read in part. A statement that the occupant has applicable rights with respect to potential service termination, etc. And at the end of Part C, we'll read that after the initial delay, certification may be renewed once to request an additional delay by providing another certificate to the utility. Right. Seeing no objection, E7. I would propose that to strike that section entirely. I believe that these regulations are designed to provide notice to the occupant, not notice to the customer. This provision is entirely for reminding the customer of their rights and remedies. I don't feel it's appropriate for it to be in this regulation. Any other revisions or proposals?
Mr. Chairman, I agree with you. I think that I was confused by this, which was why I asked about, did you mean customer or occupant here? And I would only just ask the companies, is there a reason that the occupants should know what with the landlord or the building owners, was there a specific reason you wanted them to know that? I'd like to ask that question.
So, again, our thought in this was to provide the occupants with information they may not be receiving from the customer if it's a non-active management company or association or something of that sort. Conceivably, if it's an active association, they receive termination notice or notices, they know their rights, the customer can talk to them about those, or maybe they inform actively the occupant, of those. But here you may very well be dealing with a management company or association that is not actively participating in any stages of this process. And so we thought it would be potentially useful to alert the occupant of those rights so that they can then go and proactively talk to the customer of record, meaning their board, management company, whoever it may be, and proactively ask them, have you done this? It says you can. Have you contested this? So basically alert them of certain rights that they are not given as the customer of record, but may not otherwise know about.
Mm-hmm. I guess my concern, which goes along with the chairman, is that I think it's confusing potentially that they're going to not be able to distinguish what's their rights versus the owners or the building owner, whoever has the account. And so they may think that might prompt calls to the Public Service Commission saying, I have an appeal right or something like that. That was kind of my concern with the confusion. So I think I'll agree with the chairman on that one.
Commissioner Richard.
It doesn't matter now, does it? No, I did think it made a good point, though, and maybe sometimes you err on the side of too much information, but having served on condo association, boards and been president, and sometimes it's good to have an informed building occupants. But perhaps in the scenarios we're looking at, this could just be confusing. So anyway, it's just for a vote. So
provision E7 is struck. Any proposed edits to E8? E9.
Wait.
Commissioner O'Donnell.
I believe OPC, Mr. Raker had offered to come up with some language to modify the second part of that paragraph.
Yes, Commissioner, you are right. I just on the fly, possibly changing subpart B to read financial. So from, as currently written, from financial to program, striking that and inserting instead financial assistance towards utility bill payments through the Maryland Energy Assistance Program would be available, but only to limited income individuals upon relocation.
Well, not just upon relocation, but it has to be upon relocation and establishing an account with the utility, right?
In their own name.
In their own name. So the language that BG&E suggests.
So we can add that and keep that in. And also one minor modification. It would be the website for the Maryland Department of Human Services instead of Maryland Department of Human Resources. That's the new home of the Office of Home Energy Programs.
Mr. Raker, could you just read that back one more time, B?
Yes, so financial assistance towards utility bill payments through the Maryland Energy Assistance Program would be available, but only to limited income individuals upon relocation. And I think there was an additional attachment to that, and initiating utility service in their own name,
How about establishment of a utility account in their own name?
as proposed by BG.
As
Yes.
proposed by BG&E.
That's a mouthful, but I could support that.
I can support that.
Yeah, no objection.
And Commissioner Linton, do you support?
I do support. My only hesitation is the specific reference to the Maryland Energy Assistance Program. But if the parties are comfortable with that, that's fine.
Thank you. Those revisions are adopted to Part E9. Moving forward to E10, we had some discussion whether or not the Attorney General's office should be mentioned. Commissioner Linton, I would ask you, I think the conversation was to include the AG's office in Part 10. Is that correct?
That is correct, Mr. Chairman.
Commissioner Linton, did you intend to put in Consumer Protection Division?
Yes.
I would support that.
So perhaps we would replace, that'd be instead of A, B, and C, to be A, B, and C, C and D now. In one of those positions, perhaps a new C would be notifying the Consumer Protection, is that correct? Consumer Protection Division?
Office of the Attorney General, Consumer Protection Division. Maryland, I guess we would say Maryland Office of the Attorney General, Consumer Protection Division.
Any objection? Seeing none. Moving on to F, G, Part H. I have a proposal with respect to Part H to address a concern raised by Potomac Edison. There may be instances where an occupant lives in a jurisdiction which may have more than one social services director or office. I would change the third line of H to state that they need contact OER, People's Counsel, as well as any, instead of the, any director of the social services for the political subdivision, in parens S, subdivision or divisions, in which the master meter building is located. I think it's appropriate to contact one social services director. If you live in a jurisdiction with three, I don't think it's necessary for the utility to contact, let's say, a local, a city, and a county. Therefore, the word any will allow a social services director to receive contact from the utility. Are there any other proposals to Part H?
Yes, Mr. Chairman, just a friendly amendment to your proposal would be to also include the Consumer Protection Division of the Attorney General's office here as well.
No objection to that. Any additional?
Mr. Chairman, the staff had, I believe, proposed to ask for a description of the notice. They had proposed a extensive change, something along, and I was I think I got it, but
Right,
I think
the
they had
checklist,
proposed,
right.
upon notifying the occupants of a master metered building of a pending service termination, the utility shall provide OER, OPC, and the directors of social services of documentation when the notice was given, the form of notice given, and if posted, a list of notifications or a list where the notice was posted, something along those lines. So I just throw that out there, but to me, I think you could potentially make it simpler and say provide, on the second line, say provide written and electronic notice of its intention to terminate and the description of the notice provided, or something like that, where you might just be able to sort of short track that, Mr. Spivak?
I did find staff's proposal, number 2 of its proposals, to be too prescriptive for my
Right.
comfort.
That's,
Certainly, we're open to whatever the commission would consider appropriate there. And if it's a little less specific and less prescriptive, that would be fine.
I would be comfortable with not adopting a staff's proposal. It is well-intentioned. However, if there is a modification or proposal to streamline it, I would be open.
Mr. Chairman, if we were to add at the very end of that section, as well as a description of the notice provided, I'm not sure if that works.
I would be comfortable with that. Other commissioners?
I'll support it. Could we modify that, though, to say a brief description of the notice provided? Instead of an elaborate, I mean, I don't see the whole utility of this, but I'll support it if it makes others feel better.
Right, we posted them on the front door and the elevator. Yeah. Okay. So with those changes that I proposed, along with Commissioner Linton's change, Commissioner Herman's proposal at the end as modified by Commissioner O'Donnell, Part H is approved.
Thank you, Commissioner.
Thank you, Mr. Spivak. Part I would propose deleting Part I in its entirety. I was persuaded by the arguments of Potomac Edison as to why utilities should bear the burden of providing notification after a customer has remedied their outstanding balances owed. It didn't make a lot of sense to me, but I'd be interested in my colleagues' perspectives.
My own opinion is it will be intuitively obvious that the lights or the gas have been turned back on, Mr. Chairman. I don't think you need the notification.
Thank you.
Well, this may be in an instance before termination actually occurs. If for some reason within that 14-day window, the customer negotiates a payment plan where not maybe necessarily all payments are rendered, like, again, going back to Lynn Hill.
It will be just as obvious then, Mr. Raker. But the lights or the gas are back on.
Well, but they may not ever be terminated, Commissioner. So if you have that...
And that's a good thing.
Well, yes.
I don't see the utility in this provision, Mr. Chairman. I just don't. I don't see what...
The customer may be in a bit of limbo, though, without much knowledge, or the occupant, rather, may be in a bit of limbo without much knowledge of what's going on behind the scenes.
Perhaps somebody else could inform the occupants in that case.
And that may be true, but we don't need to greatly complicate this stuff. In my opinion, Mr. Chairman, the juice isn't worth the squeeze on this particular provision. It complicates something that's going to be obvious anyway. It's another notice requirement that required to comply with, and may provide legal grounds if it's not met for very little benefit.
Thank you. Other commissioners?
I actually agree, Mr. Chairman. I would agree with striking this provision. I understand what the goal is here, but I think with the other notices that have been provided, consumers have some other avenues to find out what the status is by contacting either the customer or by calling the utility company. They have that information would have been provided in other notices.
Thank you. Commissioner Richard?
Yeah, I guess listening to the discussion, initially, I guess the concern would be that, that the occupants think that they're about to lose electric and gas, and they may be taking extraordinary measures to find new accommodations and really kind of move, perhaps. Was that the reason you suggested to really kind of quickly get the message out that everyone could be calm, that electric and gas will continue?
Right, and that is exactly right. And as I just made brief reference to sort of back to the Lynn Hill matter, there were multiple sort of instances of attempted negotiation, and then that didn't go through, and then negotiations again, payments were made, additional negotiations, payments were made, which may be the circumstance or large master metered buildings face, because it is a large customer, and certainly it's to the advantage of the utility to attempt to work out some sort of a payment plan or negotiation. And as you mentioned, especially in the Lynn Hill manner, where there were a number of handicapped and persons with medical illnesses, taking those extraordinary measures would indeed require a lot of resources, and especially financial resources. So it would be to their advantage to know that indeed service is not being terminated within just a few days.
I would only argue that the management would be in a better position to more timely notify its tenants, who they have a privity of contract and responsibility to, rather than have the utility come provide notice sometime after the fact. Commissioner Herman.
I agree with the deletion.
Okay. Part I, this is 6I, I believe, is struck. Okay, we only have one more section before between us and lunch. That is Part J. I was convinced by Baltimore Gas and Electric's proposal to add additional language, which would contain 2 additional sentences to be attached to Part J. And those sentences would read, "It shall be the responsibility of the customer to inform the utility that services being provided to a master metered building. The utility shall ask the customer at a time a new service application is submitted whether service is requested at a master metered building." I see undue burden placed on the utilities at this point, since they do not know what buildings are master metered. It sounds like that BG&E has a good program in place. I understand Pepco's situation is a little bit different. For those reasons, I would propose that we amend J with those 2 additional sentences. Any other proposals to Part J? Any comments on or concerns with my proposal?
I'm comfortable with that change, Mr. Chairman.
I'm fine.
I'm fine.
I think I'm comfortable with it. It would be good if the utility asked in some kind of formal manner, or that somehow existing. I mean, it's one thing going forward that master meter buildings, will be required to provide that information, but this would be a new requirement. And so, I mean, is there some kind of a notification that can go out in an electric bill or something that this is now a responsibility of existing master metered buildings? That would be my only comment on that. It's just
So just one point of clarification, would it be the intent then for the regulations only to apply in an instance where the customer actively informs the utility that the utility is providing service to a master metered building, and if termination happens to occur to a master metered building where the customer of record doesn't take that proactive step, the utility is off the hook from all of these requirements? I see that as a possible concern with BG's amendment. As I noted before, we would agree with the last sentence there, that certainly going into the future, customers should be proactively asked that question. But in terms of current accounts, it seems that
Well, yes, if the utility does not know that they have a master meter customer, then by virtue of that, they would not know that these regulations applying to master meter customers applied in this very instance. I think Commissioner Richards' point is a good one. Utilities should take notice to the extent that they have a large condominium such as Lynn Hill, and could deduce that perhaps we have a master metered situation here. These old buildings, like the apartment building behind me, which also has a master meter. In those situations, the utilities should use best efforts to determine who they are. I think going forward, prospectively, we'll have that all nailed down. BG has a system, as they explained, currently to identify and tag master metered facilities as they discover them. But it would be helpful if the utilities did some outreach on their own.
Well, and also I hear the point that we don't want to necessarily just now get out of jail free card here because we've created this new responsibility on the side of the customer.
Mr. Raker raises a good point there. I think if we catch wind of anything similar to a Lynn Hill condominium situation, that the utility would be on notice that these provisions do apply.
Mr. Chairman, if I may just add, our intention would also be to put some sort of information in our annual consumer reference book that goes to all customers about notifying us to the extent that their building is a master meter building. So we would certainly perform that type of outreach to educate our customers on any new regulations that the Commission adopts.
And we would expect that of all the major utilities to do so. Okay, we reached the end of our...
So are we just going to just provide that sentence without any kind of qualifier that there'll be some notice given that this is occurring, that this is now a new responsibility?
Does not the second sentence not state that of the two?
We are adding those sentences.
Yeah, no, it just we would be adding that it shall be the responsibility of the customer to inform the utility that service is being provided to a master meter building, and going forward, the utility shall ask the customer at the time of new service application. So, I think that third sentence is fine. I just, concerned about all the existing master meter buildings out there right now that we are providing a new directive.
Commissioner Richard, if you bear with me a second, I've seemed to have lost my proposal here.
Maybe while we're thinking about this, does People's Counsel have any suggestion on maybe how to implement that?
I think we do agree with your concern, and I think that echoes some of the things that I've been saying in terms of how can the utility proactively then reach out to their current customer base and understand which customers are master metered customers. We would be open to hearing recommendations from the utilities, what would be most cost effective and most efficient for them to do in that effort. But we do agree that somehow the responsibility should not all be shifted to to current master metered accounts to proactively notify the utility.
Perhaps Mr. Krieger has a proposal.
Thank you, Mr. Chairman. I'm working on the language now, but I'm thinking to the extent we just add it at the end of the last sentence, and publish information about, receiving service at master meter buildings and their annual consumer pamphlets or something like that, so that there at least is a forum to provide information to current customers, any changes, something like that. Tweaking the language, but that's sort of the notion.
Does that help?
I think it helps, but I will take a moment to think about that. That wasn't on the on the agenda, so we'll certainly consider that. Another question is, when does the annual notice go out in time for this upcoming winter season, as Commissioner O'Donnell noted, to make sure that the master metered account holders are informed in advance?
But I'm Mr. Raker, are you I'm sorry.
Go ahead.
Are you suggesting that these rules would only apply to prospective customers that identify? I think you're reading more into that provision than, we've already heard that these companies have already identified master metered customers, and they would apply these regulations to those master meter customers. This is just a way of trying to you know, what we also heard was if we go out there and we see it's a disconnection, it looks like a master metered, we're going to know it's master metered and we're going to follow these rules. So I guess I'm trying to, I'm not reading this J that just sort of says, oh, well, this only applies to somebody who in the future prospectively identifies as a master metered building.
So the initial reading of, at least our initial reading of that second sentence was possibly limiting the scope to only those customers, basically shifting the responsibility to those customers to self-identify. And then once they're on the utilities record as having been self-identified, that's when the notice provision would apply to them.
When you say the second sentence, the sentence saying the utility shall ask the customer?
Well, it shall be the responsibility of the customer.
Yes. The first modified addition or the second new sentence.
The alternative to that is actually doing a 100% survey of the service territory to chronicle the master metered buildings. And you're not suggesting we do that, are you? Because that's not going to get done by this winter either.
Well, maybe there's a middle ground of some sort.
So I think the company is proposing a middle ground by some kind of communication and outreach.
Mr. Krieger, have you had time to refine your proposal?
I think this is what I've come up with. So the sentence would be modified at the end to read, the utility shall ask the customer at the time a new service application is submitted whether service is requested at a master metered building and publish information about how to notify a utility that service is being provided to a master meter building in an annual consumer publication. A little wordy, but
if that's the language we go with, I would modify it to also include notice on your website and other places.
the website would be fine too. We could do the website.
Because the annual notice that you're referencing only goes to customers, so occupants won't get it. I mean, I guess they could call too, if they want.
I mean, the intent I think here is to make sure that the customer tells us
right.
that it's a master meter building, but we can certainly put something on our website as well.
I would ask
I'm speaking for BG, of course. But
I would ask all the state's utilities to take similar actions, both websites and other written notifications. All right, so we have something to work with Mr. Krieger's proposal there. At this point, I'm going to make a proposal regarding procedure and process, but I want to make sure I didn't short-circuit any more discussion on what we have before us.
Mr. Chairman, I'm struggling with my 20-day vote. I'm really struggling with that.
Do you wish to change your vote?
I do.
Okay. The record shall...
I'm struggling, so, yes.
Record shall reflect that Commissioner Herman has changed her vote from
Thank you.
20 days to 14. Do any commissioners wish to change their vote?
Not change. I just do hope we give everyone the full 14 days, and if we are mailing notices out postmarked 14 days, that we don't in fact short circuit someone out there, because these are essential services, and I think we ought to err on the side of caution and making sure people do get the notice. So I am disappointed to hear that we are dropping that to 14 days. So.
Okay, so as noted, the proposal to COMAR 20.31.3.6 B1 will change from proposed 20 days to proposed 14 days. Any further revisions or items before us on the red line? Seeing none. I am cognizant of the concerns raised by both Potomac Edison and Columbia Gas earlier today with respect to notice. I strongly believe, however, that the Commission provided sufficient notice when it issued its public announcement on July the 23rd of this year. Additionally, parties will have the ability to review any of our proposed changes today once the Maryland Register officially notes this in the notes these proposed rules in the Register. That being said, I think it is a unique situation, and I would be supportive of allowing a short period of time to pass to allow the parties to consider these changes, to speak with each other. It does appear that Potomac Edison, Columbia Gas, and perhaps some other utilities in the state were not fully engaged. For these reasons, I would propose to my fellow commissioners that we take a brief delay of approximately 2 weeks to allow parties to consider what we have modified today as the marker that we've set out there before these are formally published in the Maryland Register. How do my colleagues feel? Commissioner Richard?
Yeah, no, I support that proposal. I think it is a prudent way to go, and just ensuring that we do have proper input from all the impacted parties.
Commissioner O'Donnell?
Mr. Chairman, I'm supportive of that notion. I've come to understand that we have issued our notice of proposed rulemaking in a manner that we have always issued our notice of proposed rulemaking, even in this case. But that what has changed and what is different and unique in these circumstances is the fact that this results from a settlement between a confined number of parties, and that staff or someone else in the commission may have sent these notices of proposed rulemaking out to a listserv that didn't occur in this case. So I think it's appropriate that we give the extra time, and my hope is that informal sharing of the notice of proposed rulemaking would occur in this instance. So in other words, we're going to, if the commission approves this completely, we're going to have another notice of proposed rulemaking go out today for 14 days hence, and then I would ask that the traditional informal way of sharing that to a broader universe occur in this instance.
Commissioner Linton?
I'm comfortable with the proposal, Mr. Chairman. I was going to say that the notices will go out in 14 days, but everybody should be receiving them in the mail properly.
Commissioner Herman?
I support the proposal, Mr. Chairman. Thank you.
Thank you. Madam Secretary, would it be, do we have a date where we could reschedule this hearing?
Yes, September 4th in the afternoon, starting at 1 p.m.
Thank you. Notice hereby given to be followed by a notice issued today on our website providing 14 days. Hope everybody took good notes today because you will be the keepers of all the edits. I would strongly encourage the utilities that did not participate with the settling parties to make contacts forthwith. Mr. Trout, you're keeping me from lunch.
Then I will be very brief.
Please.
And say thank you. We very much appreciate the special consideration the Commission has given to all the comments that they've received, and in particular your consideration to the concerns we raised. Thank you very much.
Thank you, Mr. Trout. As the Secretary said, we'll be meeting, Madam Secretary, in the afternoon of...
Yes, Mr. Chairman, at 1 p.m.
At 1 p.m. This will be a relatively brief hearing, so be prepared to come with your best arguments or concerns based on the proposed rules that the commissioners voted on today. This meeting is adjourned.